For judgment, item number 1, AHO 34 of 2000.
The appeal is allowed. The cost of rupees 10,000 which shall be paid by the LRs of respondent 1 to the appellant within 4 weeks.
Item number 2, JCRLA 101 of 2004.
The appeal is dismissed. The bail bonds are cancelled. The appellant will surrender forthwith.
Item number 3, WPC 16574 of 2011.
The writ petition is dismissed. No orders.
Virtual mention.
None appears dismissed.
Weekly list, old matter, item number 2.
Item 2, my lords, on behalf of Mr. Milan Kanungo, the matter has become infructuous. There are two connected matters.
All right. Counsel, the petitioner states this. Petition has been rendered infructuous.
Grateful notes.
Weekly list, item number 3.
My lord, the tax effect is 28,000.
All right. In view of the significant tax amount, The revision petition is not entertained. The question is left open for decision in some other appropriate case.
Weekly list item number 4.
4, my lord, it's 18,000.
All right, same order in 4.
Weekly list item 5.
None appears to not was sufficient.
Weekly list item number 6.
My lord, this matter perhaps is wrongly formed. Yesterday,
Wrongly listed. All right.
Weekly list item number 7.
it's my lord 3,000 somehow.
All right. Same insignificant tax.
Weekly list item number 8.
8, it's 17,000.
Okay. Insignificant tax amount. All right.
Weekly list item number 9.
I'm appearing for the respondent.
My lord, 62,000.
All right. Again, insignificant tax amount.
Weekly list item number 10.
May it please your lordship.
Yes.
Here, my lords, the petitioner before lordship manufactures and effects sale of HDPE fabric, which is exempted as artificial silk under entry 22 of the list A, that is exempted goods. Whereas what happened for the period 97-98, the petitioner was assessed by the assessing officer annexer 1 page 9, and a demand of rupees 2,44,000 was raised.
Yes.
Then, my lords, I lost in first appeal, that is annexer 2 page 13, my lords. Then I also lost before the
Tribunal.
tribunal. My lords, prior to this order, the full bench of the Orissa Sales Tax Tribunal decided the issue in my favor. That is annexer 4 page 22. Page 20, my lords may kindly see.
Right.
Annexer 4 page 20, the full bench for the period 87-88 decided it. Lordship will kindly see page 21, para 4, having considered the respective contention of the parties in the light of the materials available on record and the reasons which weighed with the learned assessing officer and the learned SCST, and keeping in view the principles decided in the case of State of Tamil Nadu versus Polyweb Private Limited 51 STC page 364 and Commission of Sales Tax UP Lucknow versus Kanpur Plastic Pack Private Limited 57 STC.
No, so are you selling HDPE sacks or you're only selling the cloth?
Fabric mailers. HDP fabric I claimed as exemption.
I see.
And
You're not selling bags.
no. Since the assessee affected HDP pieces, Lordship will kindly see, I'll remove the, and not HDP sacks. Kindly see, page 22, para 5, there's a factual finding, my lords.
No, but this is in some Costa papers or something.
Huh?
Some other case.
No, not in my case, my lords.
Costa Polymers.
It deals in both, my lord. Sacks as well as fabrics. This petitioner deals in both sacks as well as fabrics.
Okay. No. Is this petitioner Costa Polymers?
Sita polymer. Sorry, my lords. But I have a judgment also of the tribunal of the same assessee, my lords. That not, I am not.
No.
That-
Your Utkal Polyweave, correct?
Polyweave, yes.
But the full bench is in some other case.
Full bench is of the other, but I have got a decision of the full bench of this same SSC where they agreed. And unfortunately, I'm not able to get it. That has been decided by this Honorable Court in 2019, my lords, by the Honorable then Chief Justice and Justice K.R. Mahapatra. They said that how can you disobey the order of the full bench of the Orissa Sales Tax Tribunal? I have got that,
You produce all that.
my lords. Lords, you may give me 2 days time.
Mr. Rice, it's time to produce the relevant judgments.
I escaped
After the vacation.
after vacation.
23rd June. 23rd June.
I think that day reopening is,
That's the reopening week.
yes. Obliged.
All right.
Weekly list item 11.
Mate, please, my lords. My lords, on behalf of Mr. Sahu, my lords, we need one Passover, my lords, after lunch, my lords.
All right. Not after lunch, Passover.
My lords, may kindly be taken after lunch, my lords.
We're not sure of that, please. We'll just first let us pass over. Yes.
My lords, one Passover. Deeply obliged, my lords.
Quick list item number 12.
My lord, delay of 5 years.
Delay 5 years, unexplained. So the application for continuation of delay is dismissed. Accordingly, the revision is dismissed.
Quick list item number 13.
May I please, your lordship? Lord, in this description, your lordship have framed two questions of law. The relevant dispute before your lordship, whether renting of aircraft will come and taxable under the head of right to use or not. That the petitioner has rented his aircraft for transportation facilities for others, and he has been paid some amount against that services provided to the customers. The learned assessing officer has held that it will come under the come under sale as it is a right to use of the goods.
Transfer of right to transfer of the
Transfer of right to use of the goods.
All right.
And the learned first appellate authority has allowed our appeal. The tribunal, if your lordship will come to page 63, Milord. Para 4.
This is all the pre-service tax regime. This is
Yes,
actually a
Milord.
service. So it's amenable to service tax.
Yes, ma'am.
All right. It's been admitted, right? The present, yeah.
Page 63, Milord. Para 4. We have heard both the parties. Peruse the order of assessment and the orders of appeal. Consider the oral arguments made before us. Also carefully examine the written submission along with the relevant documents enclosed herewith. We find that there are two issues involved in the present appeal. Whether receipt of higher charges on leasing out the aircraft for a valuable consideration would amount to deemed sale within the meaning of section 2G IV of the OST Act, so as to attract the levy of tax under the OST Act. But the second point has been allowed by the tribunal, so I am not. Coming to the first question, next paragraph, Milord. We find that both the parties are holding opposite views with each other, while the respondent says that these are not taxable sales in view of the decision of the tribunal in full bench case. The learned SR hold that these are clearly transfer of right to use transactions and taxable in the light of law pronounced by the Honorable Supreme Court of India in the 20th century case. We peruse the order passed by the Honorable Tribunal in full bench number such and such, wherein a similar question is found to have been decided to hold that the transactions are not exigible to tax. Of course, the honorable members had no occasion then to go through the law pronounced in the 20th century case. Perusal of the said judgment in para 26 thereof and para 35 would go to show that the control, custody, possession, which are usually held as the relevant attributes of a leasing transaction, are ultimately held by the Honorable Appeals Court as not relevant factors to decide whether a transactions of the nature of transfer of right to use goods happens or not. The para 35E of the said judgment is extracted here below for appreciation. Then he has quoted the judgment. The next paragraph. It is to be seen that the Honorable Apex Court have conclusively held that these transactions are not treated as contract of bailment. Therefore, consideration of control, custody, and possession cannot be fastened with such transaction to give an appearance that they are higher charges. So, in view of this, we are now guided by the law pronounced by the Honorable Apex Court. We therefore now hold that the impugned transactions are exigible to
was
tax.
not about
under the-
aircraft lease at all. 20th century was not about aircraft lease.
No, my lord. 20th century is about the lease financing law. And if your lordship will see the decision of the 20th century, it starts from page 1, my lord. What are the issues before the Supreme Court is at page 5, my lord. Page 5, para 5, my lord. My lord, got it?
Yes.
On the argument of the learned counsel for the parties, the question that arise for consideration are: what are the limitations on the power of the state to levy tax on transaction of transfer of right to use of any goods? And B, where is the citus of the taxable event on the transfer of right to use goods under Article 366(29) D of the Constitution? Before we did, then your lordship kindly turn to page 17, my lord. Lord, the learned tribunal has relied upon this paragraph. Para 26. Next question arises for consideration: where is the taxable event on the transfer of the right to use of the goods? So the question before the Honorable Supreme Court: where is the taxable event has occurred? Not where the whether it is a transfer of right to use or not. My lord, if your lordship will come to the middle of the paragraph, clause 29A, my lord.
Yes.
Clause 29A cannot, in our view, be read as implying the tax under subclause D is to be imposed not on the transfer of right to use goods, but on the delivery of the goods for use. Nor, in our view, can a transfer of right to use goods in subclause D of clause 29A be equated with the third cert of bailment referred to in bailment by Palman 1979 edition, page 88. The third sort referred to that is when goods are left with the bailee to be used by him for hire, which implies the transfer of the goods to the bailee. In the case subclause D, the goods are not required to be left with the transferee. All that is required is that there is a transfer of the right to use the goods. In our view, therefore, on plain construction of subclause D of clause 29A, the taxable event is the transfer of the right to use the goods regardless of when or whether the goods are delivered for use. What is required is that the goods should be existent so that they may be used, and the further contract in respect thereof is also required to be executed. My lord, then kindly turn to para 35 as page 20. This paragraph is also being relied upon by the learned tribunal. As a result of the aforesaid discussion, our conclusion are these. The state, in exercise of power entry 54 of list 2, read with article 366(29) subclause D, are not competent to levy sales tax on the transfer of right to use goods, which is a deemed sale, if such sale takes place outside the state, or is a sale in course of interstate trade and commerce, or is a sale in the course of import or export. The appropriate legislature, by creating legal fiction, can fix situs of the sale. In the absence of any such legal fiction, the situs of the sale in case of transaction of transfer of right to use any goods would be the place where the property in goods passes. That is where the written agreement transferring the right to use is executed. Where the goods are available for the transfer of right to use, the taxable event on the transfer of right to use any goods is on the transfer which results in right to use, and the situs of the sale would be the place where the contract is executed and not where the goods are located for use. In case where the goods are not in existence, or where there is an oral or implied transfer of right to use goods, such
That
transaction
doesn't apply.
may be effected by the delivery of the goods. In such case, the taxable event would be on the delivery of the goods. The transaction of transfer of right to use goods cannot be termed as contract of bailment, as it is deemed sale within the meaning of the legal fiction engrafted in clause 29A, subclause D of Article 366 of Constitution, wherein the location or delivery of the goods to put to use is immaterial. So, Honorable Supreme Court in this case, it only decided the situs of the sale. The Honorable Supreme Court in the 20th century has not given any finding whether to fall it under the transfer of right to use the goods, whether the delivery is required or not, the bailment is required or not. That has been clarified if your lordship will come to the BSNL case, Bharat Sanchar Nigam Limited, at page 47. The facts is at page 50, Milo. The principal question to be decided in this matter is the nature of the transaction by which the mobile phone connections are enjoyed. It is a sale, or it is a service of, or is it both? It is a sale. Then your lordship kindly turn to page 72, the finding portion. Here the Honorable Supreme Court has referred the 20th century decision, Milo. Para 73, Milo. With respect to the decision in 20th Century Finance Corporation Limited versus State of Maharashtra, cannot be cited as authority for proposition that delivery of possession of the good is not a necessary concomitant for completing the transaction of sale for the purpose of Article 366(29) Clause D of the Constitution. In that decision, the court had to determine where the taxable event for the purpose of sales tax took place in the context of subclause D of Article 366(29) A law. Then, in the concurring judgment, Honorable Justice Lakshmanan at page 79. Para 96 has held that to constitute a transaction of the transfer of right to use the goods, the transaction must have the following attributes. There must be a goods available for delivery. There must be a consensus and as to identity of the goods. The transferee should have a legal right to use the goods. Consequently, all legal consequences of such, including any permission or license required, therefore, should be available to the transferee. For the period during which the transferee has such legal right, it has to be the exclusion to the transferor. This is necessary concomitant of the plain language of the statute. So, my lord, here, whether the rights has been transferred or not has been decided in the full bench of the case, my lord. This BSNL judgment has come later on, and it has clarified the position that 20th century has not dealt with the transfer of right to use. It has only dealt with the situs of the sale.
Yes.
Here, admittedly, the appellant has given its aircraft to the hirers for a value, and the first appellate authority has rendered a finding in favor of the dealer, saying that there is no delivery of possession since the pilot of the aircraft remained the same.
Oh, I see.
My lord, may kindly turn to page 52, the first appellate authority's order holding in favor of the dealer. I have gone through the impugned order of page 52, my lord.
Yes.
I have gone through the impugned order of assessment, carefully examined the relevant assessment record, and duly considered the contentions taken by the appellant. As regards levy of
like
tax,
hiring a taxi.
yes,
Madam, it is as well as a higher tax, madam.
Correct.
Say air tax, madam.
Yes.
as regards levy of
So
tax,
there is this actually, there is therefore no transfer of the right to use also. There's no transfer of the right to use.
Yes, my lord. The
Ah.
pilot will always remain the same, but he has given it on hire for a
No, that
value.
giving on hire is the way of describing the transaction. It's actually a taxi service. It's an air taxi service.
Well, in giving it on hire, the appellant has,
No,
has not.
just imagine like a bicycle. Okay, you take a bicycle on hire, you're driving the bicycle yourself and you're riding it. You're completely in control of possession. Here, the full possession is not given to you. You're only allowed to occupy that vehicle while it is in while it is moving.
No, my lord, exactly. That is what I'm taking your lordship to the assessment order. Page 41, my lord. Second paragraph.
Yes.
Lastly, the dealer company has raised bills amounting to rupees 1,55,500 towards higher charges of their aircraft during the year under assessment, but the same has neither been reflected in the return figures nor any tax.
Correct. Not been treated as sales. Correct.
In this regard, the dealer company
I'm
has
sure they would have paid service tax if service tax had been levied on. It's a service render.
That's there.
My lord, kindly turn to the terms of condition of the license issued at page 24, my lord. Clause 12, my lord, the bottom of the page 24. It has been issued by the Director General of Civil Aviation. In clause 12, the right granted under this permit to the operate air transport services other than scheduled air transport service is for the benefit of the person named in the permit, whom shall not transfer or assign the same in any manner, including a contract of hire, whether oral or in writing, whereby the hirer of his aircraft becomes or is made the real operator of the service. So we cannot do it. As per the permit also, we cannot transfer any right. The maintenance is our, the permission is our, to everything belongs to us.
Correct. All right. The present revision petition by the SSC arises out of an order dated 17 September 2007, passed by the Orissa Sales Tax Tribunal. In essay number 1416 and 1415 of 2000-01. By the said issued order, the Sales Tax Tribunal reversed the order passed by the letter Assistant Commissioner of Sales Tax, KCST, Koraput Range, date 21st January 2000, allowing the SSC's appeals for the years 1990-91 and 91-92. Those appeals in turn were directed against the assessment order dated 31st March 1994, passed by the sales tax officer. What about the second one? 91, 92?
91, 92 has not been listed. It is STREV number 290 of 2008, my lord.
Oh, that will take it on board then.
My lord, similar issue.
Both these, you say STREV 289 and 290. Dated 31st March 1994 for the year 1990-91. Treating the charges collected by the higher charges collected by the SSC for letting out its on lease its aircraft would amount to sales and be amenable to sales tax under the Orissa Sales Tax Act 1947 paragraph. While admitting these revision petitions on 15th May 2008, the following questions were framed for consideration by this court. This code is the submissions of Mr. Satyajit Mishra, Learned Counsel appearing for the petitioner, and Mrs. S. Party, Learned Counsel appearing for the department. The actual transaction involves offering air transport services to several government agencies and some corporate clients, and raising invoices towards reimbursement of the cost of operation. Paragraph. It is pointed out that the Director General of Civil Aviation, while issuing permits to operate the said aircraft, had specified certain conditions. One of the relevant conditions is, what's the clause? 12. Clause 12, which reads as under, take from page 5. In other words, there is a prohibition under the permit on the petitioner transferring or assigning in any manner, including contract of hire, whether oral or in writing. So, in other words, it is the assessee who has to remain as the open condition real operator of these services. Quote. Paragraph. In the assessment order, passed by the STU Koraput Circle, which page in the assessment order is that?
My lord, assessment order starts from page 34, my lord.
On the relevant portion.
Relevant question, page 41, my lord. Page
41,
41,
right.
second paragraph.
It was noted that for the year 1991-92, dealer had raised bills. The SSC dealer had raised bills amounting to 1,55,500 towards higher charges of the aircraft. But this was not reflected in the sales turnover. Terming this as a transfer of the right to use the aircraft, the STO treated this as a deal sale and held that the higher charges received in the sum of these 155 and would be available to sales tax at 60%. When the matter traveled to the ACST by way of appeal by the SSC, Kamal said appeal was allowed by the order dated 21st January 2000. The ACST noted that SSC had not entered into any written contract with the hirers for transfer of the right to use the aircraft. At no point in time, possession of the aircraft was transferred to the hirers. Since the control of the aircraft always remained with the pilot employed by the SSC. The cost of the fuel, the salary of the pilot during the course of the flight had been borne by the SSC. As per the conditions of the statutory permit, the SSC always bore the risk, statutory obligation, and responsibility while operating the aircraft. Accordingly, it was held that this would not constitute a sale within the ambit of section 2 bracket G bracket Roman small 4 of the OST Act. In other words, it did not amount to a transfer of the right to use goods for any purpose. Paragraph. It must be noted at this stage that there is a full bench decision of the sales tax tribunal of the tribunal rendered on 31st December 1999. The SSC's own case, where it was held that the charges received by the SSC from those hiring the services of the aircraft did not amount to sale under section 2G4 of the OST Act. Paragraph. However, the tribunal has in the impugned order sought to distinguish the above judgment of the full bench by relying on the decision of the Supreme Court of India in 20th Century Finance Corporation Limited versus State of Maharashtra 2000-119 STC 182 bracket SC. So the tribunal has in the impugned order held that since the full bench of the tribunal, when it decided the issue on 31st December 1999, did not have the benefit of the above judgment of the Supreme Court in 20th Century Finance Corporation Limited, Supra. It decided the issue in favor of the SSC. Full stop. Mr. Leonard Counsel, the petitioner points out that the issue decided in 20th Century Finance Corporation Limited was regarding the situs of sale. And not whether a transaction of lease of aircraft or other machinery would be a deemed sale. Full stop. He referred to the subsequent decision of the Supreme Court in Bharat Sanchar Nigam Limited versus Union of India, 2006 145 STC 91 bracket SC, where the decision in 20th Century Finance was further explained. Paragraph. The decision in 20th Century Finance Corporation Limited, the State of Maharashtra, involved the following two questions. A, what are the limitations on the power of the state to levy tax on transactions of transfer of right to use any goods? And B, where is the situs of the taxable event on the transfer of right to use goods under Article 366, bracket 29, capital A, bracket small d of the Constitution of India. Stop. In answering the said questions, Supreme Court reached the following conclusions. Take from para 35, page 20. In the first place, it must be noted that the Supreme Court had no occasion to consider a transaction of the present nature, namely offering air taxi services by collecting charges. Stop. Secondly, the Supreme Court was not dealing with a situation where there was no actual delivery of possession of the goods or articles. In this case, aircraft to the user of such aircraft. Stop. It was only, in other words, there was no transfer of the right to use the aircraft. Stop. Paragraph. The above decision in 20th Century Finance has been further explained by the Supreme Court in Bharat Sanchar Nigam Limited versus Union of India, Supra. Stop. There, the question considered was whether a transaction involved in providing mobile phone connection was amenable to sales tax. Answering that question in the negative, the Supreme Court explained the decision of this Constitution bench in 20th Century Finance. As under, say B to B, page 72 of the compilation. In the concurring paragraph, the concurring opinion in the above, in the same decision, it was explained as under the whole of para 96, C to C. Applying the above parameters for testing whether the transaction in question is a sale, it is seen that in the present case, there is no actual transfer of the possession of the aircraft in question to the user of the aircraft. It is in all times in control of the pilot, who is an employee of the SSC. Even the maintenance of the aircraft is undertaken by the SSC, as are the statutory compliances in terms of the permit granted to the SSC. Stop. Therefore, there is no real transfer of the right to use the aircraft in the manner envisaged in 20th Century Finance Limited, Supra, and as explained in the subsequent decision in Bharat Sanchar Nigam Limited. Paragraph. In the considered view of the court, the tribunal erred in not being bound by its, in not following the binding precedent of the tribunal, of the full bench of the tribunal, in the SSC's own case, and in seeking to distinguish it on the basis of the decision in the Supreme Court in 20th Century Finance. Supra. Consequently, the impugned order of the tribunal insofar as it, consequently, the questions framed by this court are answered in favor of the SSC in against the department by holding that one, the rendering of air transport services by the SSC will not tantamount to single port sale as envisaged by section 2 bracket small g bracket 4 of the OST Act. and that the tribunal was not right, was in error in distinguishing the earlier full bench decision of the tribunal in the SSC's own case. Full stop. The impugn order of the tribunal to the above extent, as well as the corresponding order of the STO, assessment order of the STO, are hereby set aside. And the order of the ACST is restored to file. Revision petitions are disposed of the above terms.
STRA with 290 also been taken on board.
Yeah, 290. Yeah. Special order taken on board and disposed of in terms of the common judgment passed today in 289. Right.
14, no instruction.
Council to petition says there is no instruction. Disposed.
Quick list item number 15.
My lords.
15, my lord, I have just been served with an additional affidavit. So let me go through, my lord.
All right. What's the delay?
There is no delay, my lords. I have already explained those things in the miscase, my lords. The order was communicated on through post on.
What is the affidavit you filed today? I don't understand. There's no permission sought for filing any affidavit.
My lord,
There was no permission sought for filing any additional affidavit. So what is this additional affidavit about?
my lords, the petitioner has already availed the exemption for 7 years from 11289, and the same has been accepted by the department. Even in 2 orders, tribunal has accepted it. But the impugned order says that it should be, the exemption is the petitioner is eligible for exemption from the date of commercial production, not from 11289. So I have in the additional period, I have enclosed all the orders of the authorities below, availing
Exemption. So that is what you've given him, is it?
so
For other
already
years, so let me
petitioner has
for
already
other
availed.
years, what is the status for in respect of the other years?
No, these are your documents.
Already availed 7 years. Another page 4. Page 4, the petitioner has availed the exemption under 34F. The exemption shall be allowed for a period of 7 years from the effective date, that is 11289, from the date of or from the date of commercial production, whichever is later. So, date of commercial production is prior to effective date. So, petitioner has taken option to avail exemption from 11289. And accordingly, 7 years petitioner has already availed. I have enclosed all the orders, my lords.
These are all orders of your own
No,
department.
my lord, the certificate of exemption is to be given by an appropriate authority, and that cannot be interpreted by the department. That my lord has said. So,
DIC, yeah.
in absence of a certificate of exemption issued by the appropriate authority, so can the department or can the RCC say that basing on this
So
IPR?
if the department has accepted it,
My
the
lords,
department has
I-
consistently accepted it for all these years.
Sir,
So, my lord-
all the exemption certificates are here, my lords. There is no dispute on it, my lords. Because initially, the petitioner was not allowed any exemption. So the dealer has paid the tax from 2008 to 2nd October 1986 to 18/10/88. So after the promulgation of the IPR 89, the petitioner has availed from the date of commencement, that is 11289, and accordingly has availed 7 years.
Right.
As per this, all the exemption notification I have given, my lords.
Right. You just say admit the following questions of law. After question of law is framed for consideration. Take from page 11. Background facts. Are that the appellant is carrying on business under the name and style of Messrs. Sri Venkateshwar Industries at Berampur since 1961. Stop. It manufactures lozenges, sugar candy, etc. and has been registered under the Orissa Sales Tax Act 1947 OST Act. Correct. To avail of the incentives offered by the Industrial Policy Resolution of 1989, IPR 89, the petitioner submitted a proposal for establishing a new small-scale industry manufacturing biscuits by automatic mechanized process at Berampur. Stop. The District Industry Center issued a certificate dated 6 June 1988, inter alia certifying the date of commencement of commercial production of the SSE's new small-scale industry at Kapileshwar Peta to be 2nd October 1986. The case of the petitioner is that the goods produced by its new small-scale industry at Kapileshwar Peta is exempt from payment of tax in terms of the IPR 1986. For the period 1988-89, the petitioner claimed exemption in terms of the under serial number 30 FF of the list of tax-free goods before the STO. So, however, the STO by the order dated 22nd August 1989 for the year 1988-89 disallowed the exemption. Holding that the new unit was only an extension of the old unit. So the SSC then went in appeal before the Assistant Commissioner of Sales Tax, bracket ACST, who by the order dated 15th April 1991 allowed your appeal, right?
My lord.
Allowed the appeal of the SSC by holding that the new unit was not an extension of the old unit. Semicolon, that was set up after 1/4/1986 and is therefore entitled to the benefit under serial number 30FF of the tax-free list of the schedule. It was held that the SSC is entitled to the benefit available under serial number 30FF on and from 12th October 1988, but not from the date of commercial production. Two appeals, one by the department and one by the SSC, were preferred before the tribunal. It is pointed out before the tribunal that for the period 92-93, the applicant claimed exemption on the sale of finished products by virtue of serial number 34FFFF, which entitled the petitioner to exemption for a period of 7 years from 1st December 1989 or from the date of commercial production, whichever is later. Full stop. It is pointed out that since the commercial production in the petitioner's new unit started on 2nd October 1986, the relevant date would be 1st December 1989. No, which would be the relevant date, comma, the SSC was entitled to avail the exemption for a period of 7 years thereafter. That is till 30th September 1996. So, likewise, for the period 93-94, a similar claim was laid. Paragraph. Today, the petitioner has filed an additional affidavit placing in record the orders of the assessing officers allowing tax exemption on sale of finished products for the periods 1989-90, 90-91, 91-92. Full stop. These are undisputed facts. Even for the period 96-97, the exemption has been allowed on the sale of finished products. Paragraph. Consequently, for the period in question, the exemption from sales tax could not have been denied to the petitioner. The tribunal was therefore not justified in allowing the exemption with effect from 2nd October 1986 and not from 1st December 1989. paragraph. Consequently, the question framed is answered in favor of the SSC and against the department by holding that the SSC is entitled to exemption for a period of 7 years from 1st December 1980. The revision petition is discussed.
Weekly list item note 16.
16, my lord. Here the question of law that has been framed relates to whether the transaction in question falls under section 5(3) of the Central Sales Tax Act, my lord. May I take your lordship to the order of the first appellate authority. That is a page, my lord. Page
17.
Internal page 11 of the first appellate order. Internal page 11.
Yes.
Page 12, my lord. Page 12C. But I find that.
Yes.
But I find that the main dispute in this case relates to the claim of exemption of tax on an amount of rupees such and such, which has been made towards sales in course of export under section 5(3) of the CST Act. So it is felt necessary to discuss 5(3). May I place that section 5(3), my lord?
Yes.
Notwithstanding anything contained in subsection 1, the last sale or purchase of any goods preceding the sale or purchase occasioning the export of those goods out of the territory of India shall also be in course of such export, if such shall also be deemed to be, perhaps it has been missed, shall also be deemed to be in course of such export, if such last sale or purchase took place after and for the purpose of complying with the agreement or order for or in relation to such export. Next page, my lord. So it is clear that the last sale preceding the sale that occasions the export of those goods is also a sale in course of export if such sale takes place after the agreement for such export and if this sale is for the purpose of complying with that agreement. Thus, there are three following conditions, the fulfillment of which raises a sale to be in course of export. The three conditions have been elaborated. The first is the sale must be the sale last sale preceding the sale which occasions the export of those very goods. This sale must take place after the agreement for such export, and this sale must take place for the purpose of complying with that agreement. And the first appellate authority has held it to be a 5(3) sale on that, my lord, first that next paragraph. So it is now remains to be seen if the sales made by the appellant to Messrs. MMTC of India Limited, which is claimed to be one in course of export, really comes out to be the one in course of export when they're tested with the above tests provided in the law. So far as the first test is concerned, it is seen that the appellant has sold iron ores to MMTC Limited as per an agreement between them dated 31/3/85. MMTC in turn exported those goods to Japan as per an agreement dated 31/1/85 with the foreign buyer. So, my lord, these are the two findings, that the MMTC has entered into the agreement with the exporter on 31/1.
31/3.
30. No, my lord, MMTC with Japan 31/1 and thereafter on 31/3 MMTC with the appellant.
So the first condition is satisfied.
My lord, that is the finding, my lord.
Right.
Now, my lord, may I take your lordship to page 40? That's the similar finding of the tribunal. Page 40, internal page 5 of the tribunal's order.
Right.
On the basis of the above three conditions, and again we lay down. On the basis of the three conditions, the learned ACST has examined the documents placed before him. On analyzing the documents, he has observed that MMTC of India has entered into those same things have been quoted, my lord. But, my lord, here, when the agreements that has been entered into between MMTC with the exporter, when those agreements are, my lord, scrutinized, it was found that those that I have stated in my appeal memo, my memo, my lord, that MMTC has entered into agreement with 6 number of exporters. Those have been listed out. Those agreements, 31/1/85 agreement, it relates to six numbers of exporters, and those have been listed out. But my lord, when the bill of lading of MMTC was seen, my lord, it was seen that those exporters were not there. It relates to some other exports. My lord, may I turn to page 7 of my petition. From the copy of the contract entered into by the MMTC with foreign buyers, it is seen that the contract was with the following foreign buyers listed out. Then the dealer assessee claims that the contract dated 31/3/85 entered into with MMTC relates to supplier of goods to MMTC for the purpose of meeting its export commitment made to the above foreign buyers. But on verification of the bill of lading produced in support of it is seen that this relates to shipment of iron ores to different other parties, namely so and so, so and so. So these export, the sale by the appellant, the dealer in the present case does not relate to that 31/1/85 agreement, my lord. Where it is coming out? It is coming out from the, my lord, dissenting order of the learned member of the tribunal, my lord, that your lordship would find at page 43. Page 42 starts the dissenting note.
Yes.
Page 42. Then my lord may turn to page 43. From the copy of the agreement. The same thing has been quoted in our petition.
But what does the majority say on this?
My lord, majority has, that I have read out. Majority has simply said that without analyzing this aspect, they have simply said that MMTC has entered into agreement on 31/1/85 without examining with whom those agreements have been executed. That I have read out to your lordship, the first appellate order as well as the majority order.
But is that important? What I'm just saying is the transaction leading to that transaction is what we have to see, correct?
Yes, my lord. So if the agreements that have been entered into by MMTC with the exporters, that has no relationship with the sale by the appellant to MMTC, or there is no correlation, then my lord, 5.3 in fact requires 5.3 may place 5.3 of the CST Act.
Yes, that we already read out just now.
Yes, my lord, the last portion, and was for the purpose of complying with the agreement or order or for or in relation to such export. So
see, MMTC makes a large number of exports to Japan.
Yeah.
So it must be placing orders down the line, therefore, for those exports. Does it really matter that MMTC doesn't export to that very person whom it mentions in the agreement? And because both of those people are in Japan, it is an export after all.
Exported to Japan, my lord, that's an admitted fact.
And
it has been exported to
export
Japan.
after all. Correct. Yeah, there's no need for them to, wrongly avail of this benefit. You say the present revision petition seeks, which arises from an order dated 30th October 1995 of the Orissa Sales Tax Tribunal, Packet Tribunal. Dated 15 March 1996. (16 March 1996) in essay numbers 3247-48 of 1989-90. Seek to raise the following questions of law for consideration. Take from page 2. Paragraph. The background facts are that it may be noted that the tribunal has declined the application filed by the state under section 24(1) of the OST Act for making a reference of the above question to this court. So that order was passed by the tribunal on 30th October 1996. Paragraph. The respondent MMTC Limited sells iron and manganese ores inside the state as well as in the course of export. the respondent dealer is Lal and Company. Sells iron and manganese ore inside the state as well as in course of export. So a claim to an extent of 1,11,57,593.03 towards export sale was disallowed by the sales tax officer STO on the ground that the stock sold by the dealer to the exporter, that is MMTC, was mixed up with the stock of other parties, and that there was no link between the goods supplied and exported. Paragraph. The Assistant Commissioner of Sales Tax bracket ACST allowed the assessee's appeals against the assessment order. First off, the department then went in appeal before the tribunal by way of essay numbers 3247-48 of 1989-90. The majority of the tribunal agreed with the SSC that for the purposes of availing the benefit under Section 5(3) of the Central Sales Tax Act, the conditions required to be fulfilled have in fact been fulfilled in the present case. There was a dissenting opinion which noted that although the parties in Japan with whom MTC had entered into the export contract was specified, on verification of the bill of lading produced in support of such export transactions, it is found that the shipment related to 5 different parties, although in Japan. So, the dissenting note therefore concluded that, open quotation, in absence of any contract with the foreign buyers to whom MMTC had supplied iron ores, which is an essential ingredient of Section 5(3) of the CST Act, the claim of the dealer had been rightly disallowed by the STU. Paragraph. This court has heard the submissions of Mr. S.S. Padil, learned standing counsel of the department. Section 5(3) of the CST Act reads as under. Which page is that 5(3)? We had read out that 5(3) from an ACST's order, I think. Internal page 11, right? That's right. Just take from running page 28 bottom. The conditions required to be fulfilled for availing the exemption from sales tax on sales made in course of export were as follows. Take from now page 29, 1, 2, and 3. Factually, it has been found the above conditions are satisfied as far as the SEC is concerned. Stop. The SEC had no control with as regards the transactions between MMTC and its exporters. Full stop. Although it is possible that the bill of lading reveals certain other parties other than the contracts provided by MMTC to the dealer for the purpose of making supplies. The fact remains that even those other parties were only in Japan. So in other words, it does appear that the transactions between the dealer and MMTC preceded the transactions between led to the were for the purposes of the transactions of exports made by MMTC to parties in Japan. Paragraph. The essential ingredients of Section 5, bracket 3 of the CST Act having been fulfilled, the dealer was rightly granted the benefit of Section 5, bracket 3 of the CST Act. Consequently, the court does not find any substantial question of law arising for consideration from the impugned orders of the tribunal. The revision petition is accordingly dismissed.
Quickly list item number 17.
My lords, item number 17, I'm on VC, my lords.
Yes.
Item number 17, my lords, is a old matter. Records are not available.
All right. Counsel, the petitioner states that he does not have the record. Petition is accordingly dismissed with liberty to the petitioner to revive it as and when the record is able to be traced.
Obliged.
Quickly list item number 18.
Item 18, my lord, no instruction. Liberty may be given if any cause of action.
No instructions disposed of as such. Right.
Connected review petition.
Huh?
Connected.
In the review petition, I am for the opposite party, my lord, in VC, my lord.
All right. In view of the dismissal of the appeal, the present petition is also disposed of.
Weekly list item 19.
May I please your lordship? In this writ petition, I challenge the assessment order mainly on two grounds. That is, one is the submission of the audit visit report.
You can go in appeal, sir. You can file an appeal.
My lord, your lordship has already decided the questions of that audit visit report.
I thought that's before a larger bench.
No, my lord, it has been
It has been
decided, is it? All right. All right. In view of the decision.
No, my lord, but that decision is not applicable. That has been answered, my lord. But here the facts are different.
The facts is that if your lordship the counter they have filed, if your lordship will come to the counter.
In that case, you would go before the appellate authority, sir.
My lord,
Here it has been submitted within 7 days.
My lord, they have admitted that the audit visit report has been submitted beyond 7 days. kindly turn to counter page 3, my lord.
Yes.
They have quoted out the order sheet, my lord. Counter dated 21st March 2015.
Yes.
As prior 27/10/2007, as directed by the SCST Baleshwar and Baleshwar, notice in VAT 301 was issued to the dealer fixing the date to 23 November 2007. On 23 November 2007, as per the prior notice, the special audit team of Baleshwar Range Baleshwar visited the business premises of Kanika Furniture at post such and such, took detailed stock position of the firm. A statement of SA was also recorded from Bimal Kumar Agrawala, Managing Director of the firm. My lord, it is on 23 November 2007. After then, my lord, kindly come to the next page. 30th August 2008.
So almost a year after.
After a year, my lord, they have submitted the audit visit.
My lord, the requirement is after completion of audit, it has to be submitted within 7 days to the assessing officer. That's the requirement of 41.4. Now here, admittedly, 30th August 2008, the audit was completed. And on that very day, it was submitted to the assessing officer that the dealer has admitted in his petition at page 8. In his petition, my lord, at page 17.
No, you mean the audit visit took place for a whole so many months.
No, audit visit was conducted on a particular day. Audit report was completed on 30th August. The law requires that it has to be submitted to the assessing officer within 7 days. So it has been submitted on that very day.
No, can you just conveniently complete it on whichever day?
No, my lord.
Kindly see 41.4 for a minute. The requirement. 41.4 of the VAT Act, VAT Act. The unamended, my lord, kindly see. If it is an amended, my lord, the bottom, the unamended 41.4. That has been quoted at the bottom, my lord.
Yes.
After completion of tax audit of any dealer under subsection 3, the officer authorized to conduct such audit.
So you're trying to say that the audit was completed only on 30th August?
Yes, my lord.
How do we know that?
My lord, may I kindly see the audit report, my lord? Annexer 1A, my lord. That starts at page 32 of the writ application. My lord, may kindly turn to page 43, the last page of the audit report. That is dated 30th August 2008.
Correct. That's the whole point. It's begging the question. When was the audit completed is the question, please.
Yes, my lord. In that audit report, my lord, on the date of audit visit, 27th August 27, on that day, as I have quoted in my counter, the balance notice in VAT 301 was issued to the dealer fixing 23rd November 2017. Now, on 23rd November 2007, the place of business of the petitioner was visited. Now, on that day, the dealer has given an undertaking, has furnished some documents and has given an undertaking to submit some more documents at a later point of time. He has given that undertaking. That we have annexed to our counter, my lord. On that day, on the date of visit, he has given an undertaking that I will produce some more documents, give me some more time. Now, thereafter, he has given some more documents and all those documents were verified and audit report was prepared on 23rd August.
30th August.
28th August, my lord. And on that very day, the report was submitted to the assessing officer.
30th August, sir. 30th August.
30th August. So on that
but merely because he submitted you documents subsequently, will that extend your audit visit? Your audit visit is supposed to take place on a certain date. The statute seems to envisage that within 7 days of your audit visit, because although it uses the word after completion of tax audit.
The rules also require that on the date of visit, if the dealer asks for some time to produce the documents, then that time is to be given to the dealer. The rules require, the VAT rules.
No, but where does the proceeding show that he asked for time and therefore...
My lord, I have annexed 45 then.
I have annexed to my counter, my lord, the undertaking given by the dealer on the date of audit visit, my lord. That give me some more time, I will produce documents. My lord, may kindly see Annexer A by 1, page 16 to my counter affidavit. Page 17, may kindly see last line. Further, I undertake to produce copy of the audited account, bank statement, electricity consumption, etc. within a week.
Within a week, my lord.
So now thereafter he takes time.
No, he doesn't take time beyond. See, what is happening here is this. You have given yourself time. He has sought 1 week. You have not closed the audit. You are just keeping it open.
Well, that is there.
And then you're taking advantage of the fact that, okay, he did not give the papers. So whenever he gave the papers, that is the date on which he'll complete the audit.
In my humble submission, the law requires that after completion, it has to be given within 7 days, which my lord has held it to be a mandatory.
Correct.
So, but there is, my lord, in the statute, no requirement that the audit report is to be completed within a certain date or on the date of visit itself.
No. 41(4).
Yes, my lord. Within 7 days from the date of completion of the audit.
Correct.
So it is not necessary, my lord, that on the date of visit itself.
Where do you get that, please?
But the
Where
rules,
do you get that the date of visit will be different from the date of completion of audit?
that is what your lordship has held while holding that the 7 days period is mandatory. Your lordship have held in those cases. While holding that it has to be submitted within 7 days. If beyond, then it goes. The audit report is itself vitiated. In that order itself, your lordship have held so.
No, that it has to be 7 days from the completion of the audit.
After completion, your lordship.
After completion of the audit.
After completion of the audit, because all the entire proceeding cannot be completed in a day on the date of visit, your lordship. So the proceeding is going on different date. The petitioner is produced some of the papers, your lordship, and after verification, only the AVR audit has been completed and AVR has been.
When do we know in this case, when did he submit the papers? When do we know that? When did he submit the papers?
My lord, they have never asked any documents as per Rule 45, Sub-Rule 2.
No. When did you submit papers?
My lord, that the documents have never been submitted thereafter. Neither the department has asked.
Because for completion of the tax audit, there is no limitation, your lordship.
No. I can understand if he had submitted documents on 30th August and you say, okay, he submitted only today, and therefore I'm completing the tax audit today. What is that to show that he submitted documents on 30th August?
If your lordship will come to Sub-Rule 2 of Rule 45, if the learned the audit officer requires a dealer who fails to produce any accounts, records or document in course of the audit, shall, if the officer in charge of the audit team so requires by notice in Form 302, produce such accounts, records and documents in the office of the date and time specified in the notice. Admittedly, in the present case, no notice in VAT 302 has been issued. So it can be safely assumed that the audit has been completed on the date of visit of the audit.
Yes, my lord. That notice, the statutory notice for production of documents has not been issued. That I have verified from the record. But I can only submit that since he has asked for time to produce those documents, now he can take benefit of that.
No. Did he actually produce at any time after seeking time?
Yes, my lord. That he has produced.
When? He says he never produced anything.
The lordship gives me that liberty, I will file an additional affidavit to that point, on that point only.
No, there must be something. He's saying he never produced any documents.
My lord,
if he did not produce any documents, then suddenly for you one day to wake up on 30th August and say, today I'm submitting the report means no sense.
Your lordship, some time may be granted for additional affidavit after perusal of the record, your lordship. Some time may be granted, your lordship. I mean, it's some difficulty, your lordship. Because there are many cases in this regard, your lordship. Because the law, your lordship, will be settled against the revenue, your lordship.
It's a factual thing. From case to case, it will differ. On a date when you are able to show that you completed the audit only on that day, the 7-day period will start running from that date.
Your lordship, let me.
That is a settled position now. Because what we have held is only a repetition of Rule 45. Rule 45(3).
After your lordship, so far as the Jindal case, as well as your lordship has decided in Pal Construction and Kanakdhara case, that after completion of the tax audit, your lordship, after completion of the
correct. So that is only a repetition of 45(3).
So your lordship, after completion means your lordship on the date of signature on the AVR, your lordship.
No. Suppose you arbitrarily decide to sign it after 2 years after your visit. Can you take advantage of that?
No, lordship, but there is no. Your lordship.
No. You don't issue a notice asking for documents. You don't do anything. You visit on one day. 2 years later, you sign the report and you say only today I have completed the audit. 2 years later. And now you say, since I've completed the audit 2 years later, 7 days will start running from that date.
Your Lordship, my respectful submission, Your Lordship, the petitioner is no way prejudiced, Your Lordship.
What are you saying? What are you saying?
On the submission, Your Lordship, because...
The big advantage he has, you're depriving him. He can say this assessment is bad because the audit report was not submitted within 7 days.
I may be permitted to submit, Your Lordship. There are two limitations. One limitation is 41.4, that is seven days from the completion of the audit. And another is after completion of the tax audit, Your Lordship, the audit ABR is to be submitted within 7 days. And another limitation, 6 months, Your Lordship, 40-6. That 6 months from the date of receipt of ABR by the petitioner, the assessment has to be completed within a period of 6 months.
Correct.
So in between 41.4 and 42.6, no limitation has been prescribed by the statute, Your Lordship, that when the assessment notice will be issued.
No, but in 41.4 itself, if there is a violation, there's no question of going to 42.6.
Your Lordship, 41.4, that 7 days is only after completion of the tax audit, Your Lordship.
Correct. So if you arbitrarily, after visiting the premises on 1 day, you wait for 2 years to complete your audit report, and you say, I completed the audit only on that day.
Your Lordship, only 7 days time may be granted. Let me peruse the record and I may be permitted to file one additional affidavit. Because Your Lordship can understand, Your Lordship, there are huge cases, Your Lordship.
No, it all differ from case to case, right? So he has the record with
23rd 11, nothing more has been submitted.
The record doesn't have anything more. You say a short question arises for consideration in the present case. The SSC's premises was visited by the tax audit team on 23rd November 2007. Full stop. The audit report was submitted on 30th August 2008. The SSC claims that this is in violation of Section 41(4) of the Overt Act 2004, which mandates that the audit visit report (AVR) has to be submitted within 7 days of the single quote's completion of audit. Unquote. In the counter affidavit filed, the above dates are not in dispute. So it is, however, claimed that since the SSC himself wrote a letter on 23rd November 2007, seeking time for submitting further documents, the audit was not completed, awaiting those documents. Full stop. Accordingly submitted that the audit was completed only on 30th August 2008, the very date on which the AVR was submitted. Paragraph. As pointed out by counsel to the petitioner, no documents were submitted by the petitioner after the audit visit. Full stop. Even assuming that 1 week's time had been sought, the audit team could not have waited beyond 30th November 2007 for completing the audit. Full stop. It appears that there's nothing in the record which has been perused by learned additional standing counsel in court, to show that any documents were submitted by the SSC after 23rd November 2007. Full stop. Allowing for a reasonable time awaiting the documents of the SSC, the audit ought to have been completed either on 30th November or soon thereafter. Full stop. There was no warrant to wait till 30th August 2008 to complete the audit. Full stop. Consequently, the very object of Section 41(4) of the Overt Act appears to have been defeated in the present case. Paragraph. Whether in a particular case the audit was actually completed within a reasonable time after the audit visit will be dependent on the facts and circumstances of each case. So as far as the present case is concerned, the court is not prepared to accept the plea of the department, that they waited for almost a year after the audit visit to submit the AVR by treating the date of submission of the AVR to be the date of completion of audit. Consequently, since there is a violation of Section 41(4) of the OVAT Act, read with Section 45(4) of the OVAT rules, 45(3) of the OVAT rules, the court sets aside the impugned assessment order dated 15th February 2009, passed by the Joint Commissioner. The writ petition is allowed in the above terms, no order system.
Unless the tagged up matter is under the entry tax under the same thing.
Which one?
The tagged up matter. Another matter has been tagged up.
You see, writ petitions bill 7754 of 2010. In view of the order passed today in 7753 of 2010, which pertain to the assessment under the OVAT Act 2004, the impugned assessment order in the present writ petition, which is under the OET Act, is also quashed.
Your Lordship may clarify in between that on the date of audit visit and on the date of preparation of AVR, the proceeding, there was no proceeding. Your Lordship, nothing has been produced and no notice has been issued. Your Lordship may clarify that position because.
Or additionally, no notice was issued between the date of audit visit, that is 23rd November 2007, and 30th August 2008, the date of submission of the AVR. As invitation rule 45(2) to be issued in form 303.
303.
Right.
At the same time, no production on behalf of the dealer.
Yeah, that we already noted.
Yes. Gratefully.
Weekly list item number 20.
My lords, on behalf of Mr. Kamal Bihari Panda, item 20 and 21 have become infructuous.
All right, 20 and 21 matters have been rendered infructuous to disposed of.
Item 22.
Item 22, this is the appeal filed by the state.
Delay?
In fact, there is delay, my lord, 390 days. But the appeal, we have a case because the basing upon what judgment the Honorable Single Judge has allowed the writ petitions, that particular judgment has been set aside. In the other batch of writ appeals, that
2011, so we leave the question open.
Yes.
So leaving the question of law open, the writ appeal is dismissed on the ground of delay since it's extraordinary and has not been explained properly. The application is accordingly dismissed. And the writ appeal is dismissed in the above terms. Right.
Weekly list item 23.
23, both the items are permitted to be withdrawn.
Right. Counsel the petitioner seeks leave to withdraw both these writ petitions.
I'm for the opposite parties.
All the cases. All right.
Interim orders may be.
Interim orders are vacated. All right.
For Union of India, I am there.
Right.
Weekly list item 24.
Lord, in 24, because of the change of counsel, we will not serve the rejoinder copy. I think the State Information Commission has engaged some new counsel. I think Mr. Das is appearing, Mr. BK Das.
Yes, madam. I'm in the virtual mode. I'm sorry, extremely sorry.
All right.
Absolutely. So I've served a copy on him. My learned senior wants to argue the matter also. I'm ready. Otherwise, it can be taken up some other day convenient to my learned senior.
All right. Petitioner has submitted written notes of argument. Mr. Das states that he is recently engaged by the opposite party, State Information Commission. He accordingly seeks some more time to get ready with the arguments. List on 25th August.
Rejoinder also filed may be taken on the call.
Written notes of arguments and rejoinder.
Along with.
All right.
I'm grateful, madam.
Weekly list item 25.
25, my lord, no instruction.
No instructions disposed of.
Weekly list item 26.
26, my lord, I am there for the opposite party.
All right. None appears dismissed in August. All right.
Weekly list item 27.
I am in Rishi, my lord. May I please? My lord, it is the petitioner that the land was settled in the name of petitioner in 1978 under section 3 of OGLS Act.
5 and 6 have not been served.
Your Lordship,
5 and 6 opposite parties, none of them have been served. AD not back from OP9, 5 and 6 long absent, hence returned. 7, 11 and 12 refusal.
yes,
OP8 dead. OP10 not known.
Lordship, OP5 to 10 are private opposite parties.
That's what. So if they're not been served, then what's the point?
My Lord, this is the innocuous prayer, my Lord. As per direction of this Honorable Court, I filed a application for settlement under Rule 5.2 of OGLS Act before Tahsildar. But in 2011, under Annexure 6, my Lord, the Tahsildar issued a Form A for correction of RR in favor of private opposite party. Originally, his predecessor in interest was there. So, therefore, in favor of the legal for correction in R1. But that was on the basis of your...
Madam, on all this is contested claim. Unless the private opposite parties are served, one can't decide this.
Your Lordship, I pray, my Lord, if...
what is the order? Annexure 6 is passed by whom?
Annexure 6 is passed by Tahsildar. That for correction...
That's an appealable order.
Yes. Appealable order.
It's an appealable order.
That is not an order, my Lord. Your Lordship, I can't say this is my Lord, Form A notice for correction of RR. Without disposing of my application under Annexure 4 that has been issued, that is my contention. Only, my Lord, innocuous prayer before this Honorable Court, that may be disposed of in accordance with law. That is my...
All right. Which is your application?
Under Annexure 4. By virtue of
Right.
Annexure...
Counsel for the petitioner states that at this stage, the petitioner would be satisfied if a direction is issued to the Tahsildar to dispose of the petitioner's application dated 15 November 2008, bracket Annexure 4, bracket expeditiously. Paragraph, since the prayer is a limited one, a direction is issued to the Tahsildar to dispose of the said application at Annexure 4, if not already disposed of, within a period of 4 months from today in accordance with law. A copy of this order be sent to the concerned Tahsildar forthwith. The petition is disposed of.
Oh, bless.
Quick list item 28.
None appears dismissed on opposition.
Quick list item 29.
My Lord, with the liberty, my Lord, because some developments are there.
No, there's no development, so you can always file a petition.
So name
If the
of
council
Mr.
petitioner seeks leave to withdraw the present petition.
Name of Mr. Dayanda Mahapatra be recorded for opposite partner of 4 mile.
All right.
Oh, bless.
Quick list item 30.
30 please also. I have challenged Annexure 9 order of the Tahsildar, my Lord.
It's appealable, sir.
My Lord.
Appealable order.
It is appealable. Only one thing I will invite my Lord's attention why I have come before my Lord. At page 42, last paragraph, my Lord. 42. It is appealable, my Lord, I do admit. Because of this paragraph 40, the last paragraph, I have come before my Lord. 42, my Lord, may permit
Yes,
to
yes.
My Lord, at this stage, it seems appropriate to put on record that after the finalization of the rehabilitation assistance of the petitioners, question the inconsistent approach adopted by the LA collector and the LA collector in order to rectify the manifest error, resubmitted the revised proposal on the basis of some jointness of property. By this office letter number so-and-so dated 18/10, and the same proposal was rejected by the government in Water Resources Department, write their letter number so-and-so. In rejecting the proposal, the government took the ostensible stand that as the earlier rehabilitation assistance proposal relating to case property based on separate possession was already sanctioned by the letter number so-and-so, they are not going to reconsider the fresh proposal based on jointness. My case is that the joint family property has been acquired. And
why can't you argue all this before the appellate authority?
Because of this paragraph, I have come before my Lord.
Whatever, sir, the same paragraph you can argue before the appellate authority.
With that liberty, my Lord.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal in accordance with the statute in question. If such appeal is filed not later than 4 July 2022, accompanied by an application for contestation of delay, citing the pendency of the present petition as the reason for the delay, such application will be considered on its merits by the appellate authority. Full stop. The court clarifies it has not expressed any view in the matter. Full stop. The original of the annexures be returned, subject to the petitioner, counsel of the petitioner, subject to being substituted with the attested photocopy thereof. All right.
Reproved.
All right. The petition is disposed of there. Safe. The account affidavit has been filed on 27th April 2017, enclosing the finally published record of rights. Full stop. If the petitioner is aggrieved by any particular entry in the set record of rights, it will be open to the petitioner to seek appropriate remedies. The petitioner is full stop.
Weekly list item 31.
None appears to dismiss no prosecution.
Weekly list item 32.
Hey, please, Lord, I am in the VC, Lord. But I'm sorry, the file is somewhere misplaced, Lord. So I need little more time.
No, it's all right. You say counsel for the petitioner states that the file is misplaced. Petitioner is accordingly dismissed for non-prosecution, with liberty to the petitioner to revive it as and when the file is able to be traced.
Weekly list item 33.
Only our appearance may be noted. It's against a show cause. I think it might have become infruct.
All right.
Item 33.
Made, please, Your Lordship. Your Lordship, this is an writ challenging the award of the. Your Lordship, may kindly see order number 4 of this Honorable Court dated 17/12/2012. A direction was made to serve copy of miscase number 3756/2012, wherein the opposite party workmen had claimed for wages under section 17B of the Act. That copy was never served on me, and on next, that is order number 5/21/2013. While I could not attend and my associate was otherwise occupied in another court, this court has directed for payment of 17B. However, at flag C, that is miscase 938/2013, I have sought for recall of this order because all this while the workman has been engaged gainfully in another establishment.
Who's going to now verify all that, sir? Have you served the workman at all or not? In the present case, have you served the workman?
Not.
Ranjit Kumar Panda. You argue the matter in merits. What's the matter about? Award dated 25th April 2011. Yes.
Here the background fact is that the opposite party workman was engaged in the petitioner establishment as a salesman.
Yes.
And while working as such, he suddenly went on unauthorized leave. And for that purpose, he was charge sheeted. Inquiry was conducted where he did not participate. Ex parte inquiry was done. Report was submitted. Thereafter, he was so-called. He did not reply, and accordingly, he was terminated from service. But however, the opposite party workman raised a dispute before the labor authorities, alleging from the date of his unauthorized leave to have been terminated. Accordingly, a reference was made to the labor court at Bhubaneswar.
Yes.
Both the parties appeared before the labor court, and accordingly, they also filed their pleadings, and workman also examined himself as a witness from his side. At that point of time, Annexure 3 at page 24, your lordship finds both the parties decided to settle the dispute in a mutual and amicable manner under statutory form K. That is page 24, Annexure 3, your lordship.
Yes.
The terms of settlement were, it is agreed by and between the parties that Sri Prabhat Pushti shall receive a total sum of rupees 25,000 only from the management towards full and final settlement of all his claims up to date money and for service. That after receipt of this amount, Sri Pushti shall have no right to raise any kind of dispute for money or for service against the management.
No, but where have you urged this before the labor court?
Lordship, that is at page 27, your lordship, Annexure 4. This is a joint application by the management and the workmen before the labor court. And that also forms part of the order sheet at Annexure 5, your lordship.
No, but after that, 23rd June 2010, workman is present, management is absent.
Lordship, first at page 28, your lordship finds the order sheet 10/2/2010. A joint petition was filed along with the settlement for passing of the award. Thereafter, the representative of the management died, and because the matter was posted for award as per the settlement, the management did not take steps. After 4 months, that is on 23/6/2010, the workman was present on a single occasion. Thereafter, also your lordship finds on that is order number 39, 18/11/2010, the management attended, but the presiding officer was on leave.
No, that was one date, sir, but later you did not appear.
So that is because the representative of the management expired.
3 continuous dates you were absent.
That is only after the settlement. My point, I have only 2 grounds of challenge. First is, your lordship, that when a settlement is made under section 18, that has binding effect and the labor court cannot...
Unless it is accepted, please. There must be an order in terms of the settlement. Then you can say it is binding. There's no order in terms of the settlement.
That matter has not been dealt with by the learned court below.
Yes.
That is one of my grounds.
Yes.
And the second is, your lordship, this is a case of domestic
What is the
inquiry.
reason for your absence? You have to give a reasonable explanation for your absence from the labor court.
Lordship, my reason for absence was that as the matter was settled and our representative had died, it was already bona fide that award would be passed on the settlement. And behind our back, this memo has been filed, copy of which was never given to us, nor notice was issued by the labor court. We did not have any idea about that.
You are supposed to, there's no final award passed. How can you presume? It's a very lame excuse.
Lordship, we have filed a joint petition before the court below, praying for passing of the award in line of the settlement.
But you don't follow up. You don't appear in the labor court for 3 dates after that. How can you presume that the proceedings are concluded?
That is only on the bona fide that all the disputes have been settled and nothing more remains to be adjudicated. Only a formal award was to be passed, incorporating the terms of the settlement under Form K. Under that bona fide only, the petitioner had not taken any steps out thereafter. And here your lordship kindly finds that this is a case of termination after a domestic inquiry. And
you did not produce any document for that?
Because
that you held any such inquiry?
Your lordship, my humble submission is that we were not aware of the proceeding.
No, there is no such excuse, please. See, you keep coming to the court. If the presiding officer is absent, don't you find out which is the next date? On the next date, you are not present. Then the 2 more dates after that, you are not present. How can you say, I presume that the proceedings are over?
In this case, the representatives were employees of the petitioner. No lawyer was allowed in this case. Advocate engagement was not allowed in this case. So
That's all
parties
right.
were representing themselves.
Whatever, sir.
So
you're not on advocates at all. Whoever is presenting, they know how to take dates and how to find out which is the next date.
So even if that is also accepted that we have failed to attend the court and did not lead evidence, the learned court has come to the conclusion that the inquiry was unfair.
What was this man's age? What was he has not come forward either.
Lordship, in 2010 he was 40. So now
He may not even be interested in coming back, sir.
62.
What is the relief granted? Only reinstatement.
Reinstatement.
That's all. Without any other back wages, nothing. The following dispute was referred to the Labour Court for adjudication. Take from page. You say this petition is direct by the management. Challenges an award dated 20th October 2010 passed by the Labour Court Bhubaneswar in industrial dispute case number 66 of 2003. Award dated 25th April 2011. Sorry. 25th April 2011 passed by the Labour Court Bhubaneswar in ID case number 66 of 2002. Paragraph. The following question was referred to the Labour Court for adjudication. Take from page 30. Paragraph. The case of the workman was that he joined the management as a salesman in July 1993 and was declared permanent in November 1993. On 30th November 2002, he remained absent in the second half and thereafter went on leave for 2.5 days as his father had become suddenly ill. When he reported back for duty on 3rd December 2002, he was not allowed to join duty. And this gave rise to the industrial dispute, which is referred for adjudication. Paragraph. The management filed a written statement partly admitting the facts as urged by the workman. However, the contention was that the workman had deliberately absented for duty without any prior intimation and never returned to the establishment. To stop, he also deliberately refused to receive the charge sheet registered letter and it came back undelivered. Paragraph. Although the management claimed to have conducted a domestic inquiry prior to removal of the workman from service, before the Labour Court, no document was produced by the management. Paragraph. Counsel of the Labour Court, therefore, had to accept the case of the workman and proceeded to hold that the termination of his services was neither legal nor justified. Full stop. However, no relief of back wages was granted. Full stop. The Labour Court only ordered his reinstatement. Paragraph. While notice was directed to issue the present petition on 2nd January 2012, the award was stayed subject to compliance with Section 17 capital B of the Industrial Disputes Act, bracket ID Act. Counsel for the petitioner today states that the management had filed miss case number 3756
938 of 2013.
938 of 2013 seeking recall of the above order, since according to the management, the workman was gainfully employed elsewhere throughout. Be that as it may, this application was never listed before this court. Paragraph. Although counsel entered appearance on behalf of the workman, today none appears on his behalf. Paragraph. The main contention of counsel for the management is that a settlement was entered into between the parties, which was presented to the Labour Court in the form of a petition. Full stop. He refers to the proceedings before the Labour Court of 10th February 2010, which notes that there was such a joint petition, but since the presiding officer bracket PO was on leave, the matter was adjourned to 18th March 2010. Stop. Paragraph. For 3 dates thereafter, that is 18th March, 15th April, and 23rd June 2010, the management representative was absent. Full stop. Again, on 20th January 2011, 7th February 2011, and 10th March 2011 and 15th April 2011, none was present before the Labour Court. Paragraph. With the management deliberately staying away from the Labour Court, the question of the Labour Court having to accept the settlement between the parties did not arise. So someone had to be present to ask for an order to be passed in terms thereof. Full stop. Therefore, the labor court cannot be faulted for proceeding with the matter and passing the impugn award. Paragraph, the court is not satisfied that the labor court has committed any error in passing the impugn award in favor of the workmen and against the management. It calls for no interference. The petition is dismissed.
Weekly list item 34.
Your Lordship, the 17B order may be recalled only.
It's all over, sir. Petition itself is dismissed. Yes.
Item 34.
None appears dismissed and non-prosecution.
Weekly list item 35.
The lordship in identical matter, lordship has directed to file a petition before the learned labor court. The matter is regarding a group of people has raised a dispute. They have settled the matter along with the management. Since the union has not appeared, learned labor court has stated that the settlement is not acceptable. Union is not functioning last 10 years.
Same order.
Hello. Obliged.
Same order.
Weekly list item 36. Item number 36.
$3,000 demand draft. What should be done with that? Just pass it over.
36 I'm appealing for the opposite party, Bhubaneswar Development.
The continuing possession, the petitioner.
They are in possession by virtue of a lordship's interim order, but they are not paying the arrear dues. They are under Annex 14,
That 20,000 which was
29.
deposited, it's been kept in an FD, the 20,000 which they deposited.
Yes, much more amount is now due.
All right.
Now,
So this amount can be asked to be released to you then. No?
There is a provision of appeal is there.
All right. You say none appears to the petitioner. Paragraph, the challenge of the present petition. No, a direction was sought in the present petition to the Bhubaneswar Development Authority (BDA) to allow the petitioner to deposit the balance amount and allow the petitioner to continue possession of the house in question. Full stop. On 23rd July 2012, while directing notice to issue in the petition, this court directed status quo to be maintained subject to the petitioner depositing rupees 20,000 in this court within a month. Full stop. On such deposit, the amount was to be encashed and kept in a fixed deposit with a nationalized bank. Full stop. After that, no orders were passed in the present petition. Paragraph. Counsel appearing to the BDA states that because of the stay order, the petitioner continues in possession, but the amount owed by him to the BDA is has substantially increased, and he has made no payment. Paragraph. In the circumstances, while dismissing the petition, the court directs that the FDR amount, that is, together with the interest accrued, be released to the BDA within a period of 4 weeks, for which purpose the authorized representative of the BDA will appear before the Registrar Judiciary on 21st June 2022. The interim order stands vacated. The petition is dismissed.
Weekly list item 37.
None appears dismissed. No prosecution.
Weekly list item 38.
May I please, Your Lordship? I am appearing virtually, Your Lordship. In item 38, my Lordship, the complaint has been filed for non-compliance of order dated 6/7/2010, passed on Deputy number 1338 of 2008. My Lordship, I kindly see Annexure 1 of the content application. The petitioners are, my Lordship, they are the lessees and who have purchased the property from the Orissa State Housing Board Corporation. They have came in writ application for handing over the possession of the land. Pursuant to the advertisement dated 28/12/2002, Your Lordship. After that, when they have not handed over the property, in 2008, we have filed a writ application, and the Honorable Court has directed the opposite party number 1 and 2 to take immediate steps for removal of encroachment and handing over the position of the core houses to the petitioner within a period of 3 months.
Yes.
In the meantime, my Lordship, 12 years are already passed and still.
No, 23rd November 2011 order. Can you read that?
Copy of the order.
November 2011.
I'm sorry, Marshal, I don't have the copy. And also not uploaded in the website of the High Court. Now, my Lordship, on 11th of July 2018, they have filed a show cause affidavit. So, OP number 1 and 2, Orissa State Housing Board Corporation.
Have they filed any affidavit?
I want to file, Your Lordship, because in the meantime, certain development has taken place, but I have to bring in the record. Because the COVID period, the petitioners are, they all are septuagenarians. They have not come before us, but I have contacted them in the morning. They want to file a reply. Because certain development has taken place in civil suit.
What has happened in the civil suit?
The person who was already was in position, illegal position of the property, he has filed a civil suit against the government and the State Housing Board Corporation, Your Lordship.
All right.
And in the meantime, an injunction order has been passed by the learned trial court.
No, so how does this contempt still survive? I'm not able to understand.
Because
even earlier it was noted that the order passed by this court is not capable of being implemented because of all these suits and other developments.
My Lordship, the question is now, Your Lordship, before Your Lordship is, when in 2003, they have taken EMD from us and the premium as well.
No. The short question as far as the contempt petition is this. In 2010, we passed an order asking you to be put in possession.
My Lordship.
A show cause is filed pointing out the pendency of a civil suit in which orders have been passed.
My Lordship.
That suit is still pending.
No. In the meantime, my Lordship, there's a certain development. That's
what what development?
I already taken instruction, my Lordship. I have to put forth it by way of an affidavit, my Lordship. As per my instruction, the suit is not has been disposed of, Your Lordship.
No. I'm appearing for the contempt, my Lord. There are series of litigations. My video is not working, my Lord. There are series of litigations In the meantime, we have also cancelled the scheme because of the pendency of this series of litigations.
No.
One is, I have filed my counter, I mean, so-called affidavit since long, my lord. 2011.
That you have.
Cancelled. No. That is a wrong statement. In 2012, yourself, operation has issued me a notice, your lordship. I've also filed an affidavit on 23rd November 2012, your lordship.
All right, Mr. J. Biswal, learned counsel, the petitioners wants time to place on records and developments that have taken place after the show cause affidavit is filed by the opposite parties.
But fact remains, my lord, till date it is not removed. Because of pendency of the suit, encroachments could not be removed. That was one of the conditions.
At his request, he is permitted to file the affidavit within 4 weeks. List on.
Eight.
11th August.
Obliged.
Weekly list item 39.
Lordship, item number 39, it's a contempt application. We don't have any instruction in this case, my lord. Lordship, may kindly dispose it of as liberty.
Order has been complied with.
All right.
Weekly list item 40.
Unappeased dismissal not possible.
I am appearing for with high.
All right.
Weekly list item 41.
Unappeased dismissal not possible.
Weekly list item 42.
Unappeased dismissal not possible.
We have filed the compliance affidavit indicating that order has been complied with.
All right.
Weekly list item 43.
Counsel, the petitioner hands over a memo disposed of. This is withdrawn in terms of the memo.
Lordship, Mrs. Dutt's name may be reflected.
For?
Opposite part number 3 and 4.
All right.
Obliged.
Weekly list item 44.
44.
That was 40. That was 43.
I see. 44 non-appears dismissal.
We are for the union of planets.
Weekly list item 45.
45, my lord, I am for the petitioner, my lord. It's a recovery matter, my lord. Till that counter was not filed. And madam, nothing showing, my lord.
Sorry?
Extra copy not served. I solved the extra copy.
Counter is not
2013 matter. What is it about?
Counter is not required, my lord. My lord, in fact, the order is there. Lordship, kindly see the page 16 of the order of the Information Commission. I am appearing for the State Information Commission.
Yes.
Paragraph 5, Lordship, kindly see paragraph 5, page 16 of the brief.
Yes.
He said that he is responsible. 2 persons are responsible. So, out of 25,000, 12,500 and 12,500, he is responsible for the delay, my lord. Delay is more than 1 year. Deliberately has delayed. He said that because of the quarrel and disturbance, page 5, last 2 lines. He said that is further explained that due to the fracas and continuing in the public authority IA allotment such and such, and he couldn't function properly, who is led to the delay. The delay is very flimsy ground.
No, what is the order, sir?
Order, we kindly see order is there. Paragraph 4. Page 15 starts. He files show cause and after perusal of the show cause.
No, para 9. Therefore, invoking the mandatory provisions of 21, penalty of 25,000.
Yes, madam. Both 2 persons are there responsible.
There's nothing, sir. 25,000 is nothing.
12,000.
I know. You can easily pay 12,500, sir. Nothing at all.
Pardon, my lord.
You have to pay only 12,500. There's nothing. It's an insubstantial sum, sir.
Well, I was not the authority. The OP1, my lord, not furnish me any copy of complaint. I was not the authority, my lord. My lord, kindly have a glance, page 4, para 7, my lord.
Sir, you were heard before the commission, page 15. It's only after hearing you, the order was passed. You were present in person before the commission.
I filed a show cause before the OP number 1 on 29/11/2012, my lord. The same day order was passed. Any complaint petition not, sir?
No, you were present, sir. Page 15. Come to page 15.
I was present, my lord. Not denied.
Yes.
Present.
These are all information commission proceedings. It's not like a court.
My lord.
Paragraph 5, it is
I will
expressed.
peruse the impugned order of the State Information Commission, dated 29th November 2012, in complaint case number 1196/2011. The court is unable to find any legal error vitiating it. Full stop. The petitioner who is working as a junior clerk.
Junior assistant, yes. Yes.
Dealing with the Indira Awas Yojana (IAY) matter at the All Panchayat Samiti, Kendrapada. Was found to have not been prompt in providing the information sought for under the Right to Information Act 2005. All that has happened is that he's been asked to pay a penalty of rupees 12,500, and an equal amount has been imposed on his colleague. Considering that the amount is insignificant, since it works out to only rupees 12,500 per person, and even on merits, there's no case made of interference, the court is not inclined to entertain the prayer in the present petition. It is accordingly dismissed.
My name may be recorded because B and Dutt's name is there in the first.
All right.
I'm already judged.
Yes.
Weekly list item 46.
None appears dismissed now.
Weekly list item 47.
None appears dismissed now.
Weekly list item 48.
Same.
Weekly list item 49.
Cases are disposed of.
Sorry?
Cases are disposed of.
What is this?
These two cases. 49.
Yes, yes. You say this MC 1187. None appears for the applicant. With contempt case, none appears for the applicant.
I am for the opposite party.
All right. You did not file this MC.
Madam?
This miscellaneous case, did you file?
Cases were disposed of. I don't have to file, madam.
Okay. Then none appears. The applications dismissed on all.
Weekly list item 50.
Again, MC number you put down and say none appears dismissed on all. And what none is appearing.
Weekly list pastor matter item number 11. This is one matter where Lordship by order dated 9/5/2008 have framed admitted the questions of law, my lords. The question of law, my lords will find at page 11. Page 12, my lords. Three questions are framed, my lords. So whether in the facts and circumstance case, the law and tribunal is aid in law by disallowing the tax exemption on sale of finished products manufactured by industrial unit under diversification scheme. Whether in the fact and circumstance case, the order of enhancement of assessment passed by law and tribunal without compliance of provision rule 53 of the Orissa sales tax rules is lawful and valid. And lastly, whether in the fact or case the learned tribunal has committed error of jurisdiction or is erred in law while deciding issues which are not before him in the appeal filed by the petitioner in absence of cross objection filed by the state. It's all these three questions. Let me address together, so that means the third, which is little different, the question in jurisdiction tribunal can also be decided. I will also place. This is a case where the permanent registration certificate, which I have annexed with the revision application by annexure 1, if you will also kindly see at page 15 of the brief. Under Industrial Policy Resolution 1989, which is operative from 1st December 1989, after continuing business operation, I underwent expansion. Thereafter, diversification. Let me address your lordship in brief. What is the expansion diversification? I will also refer to your lordship's judgment of Jharkhand High Court. They have clarified what is the scope of expansion and diversification, and that stands contrast to the original operation. Supposing somebody in the original unit is producing, supposing 100 units and manufacturing a particular item A, B, and he undergoes expansion. Expansion means instead of 100 units, it may be 400 by adopting technology or whatever. And diversification is completely different. I was supposing, in this case, I was manufacturing steel aluminium racks, but by of diversification, I completely diversified to different items. Now, the item which I am manufacturing diversification is foundation packing, rings, gaskets packing, exhaust smoke channel, electrical panel board, seat, all these, which are completely different from the one that I was, because that was not viable, so I decided to diversify, and that was permitted by the district industry center. They amended it also in my permanent residence certificate, because the exempt certificate also granted us. Now, when the dispute arose, your lordship will find from order of assessment that they have passed. In the that order of assessment, I have been page 25. It starts with us. Relevant page 27. The assessee has not shown production of page 27. The assessee has not shown production of steel almirah, rack, table, and air cooler cabinet for the stated that due to no demand of said produce the market and general sales restriction, he has not manufactured said goods. It has been envisaged in the classification issued by the Director of Industries in IPR 89 letter number so that as per provisions of IPR 89, the industrial units undertaken expansion, modernization, diversification projects are eligible for sales tax benefits only to the extent of increased capacity over and above the existing capacity, irrespective of items manufactured by the original unit. The entries under 26 FF and 30 FFF2 for sales tax exemption on the purchase of raw material and sale of finished products allow exemption to the extent of increased commercial production over and above the existing installed capacity. This means that the unit is eligible to avail tax benefit under these entries only in respect of increased production. The production of the original unit is to be excluded from his exemption. The unit cannot stop production of the original unit and therefore cannot claim benefit of entire production for expansion, modernization, diversification. Now let me clarify this. But supposing if in the original unit I do not go for any manufacture, I do not produce anything, there is the interpretation of the assessing officer that you have to pay tax on that even if you do not manufacture that. And what he did, he assumed, he estimated notional manufacture. If I would have produced, then how much I could have produced. And he estimated at page 28 that my assumed production from the original unit would have been 8,50,000, and out of 36 lakhs somewhat, giving deduction to that because saying that you are not entitled to original production. So therefore, the balance only you are entitled. Page 28, you will also be kindly see. Paragraph, first starting paragraph, 5 lines from the bottom. Total value of steel almirah, rack, table, air cooler, cabinet comes to 8,50,465. Total sale of finished goods shown for 36 lakhs so and so. Tax exemption is not admissible on 8,50,000, being the sale price of steel almirah, rack, table, air cabinet estimated now to be best of judgment. Tax exemption is admissible on rupees 27 lakhs so and so out of 36 lakhs claimed to tax exemption sale by the dealer. But this is how the assessment is made. Assuming production from original as a notional manufacturer, as if I have done that, and they have proceeded to assess. Now, my humble submission is the London Tribunal also will first appeal dismissed, approving the assessment made by the assessing authority. Now, Tribunal more or less, apart from the other issue which I will address, Lords, regarding enhancing the entire thing, not only the issues which are not before the Tribunal, which your Lordship in the judgment I will refer to, he has no power also, Lords, unless there is a cross appeal or cross objection by the revenue. The Tribunal has no power to expand the scope of appeal, because statute has permitted the state, if aggrieved, to file appeal, to file cross objection, even if appeal is not filed. Without doing so, you can't, in my appeal, enhance the scope of appeal. That is what forbidden by our High Court. Now, my lords, taking that part later on, so far as Honorable Tribunal is concerned, your Lordship will see at page 40, the operative portion of the order, paragraph 4 of the judgment order, my lords. We have heard rival submission of both the parties, gone through the orders of fora below vis-a-vis the materials on record. Of course, under industrial policy resolution, the concession is available only in respect of increased commercial production over and above the installed capacity, as it existed prior to expansion, modernization, diversification of any industrial unit. Evidently, in the instant case, there was a nil production and sale of goods pertinent to existing industrial capacity as certified by the DIC, but production and sale under diversification scheme, which cannot at all be called as increased commercial production over and above the installed capacity of the unit, and as such, clearly violates the stipulation laid down notification of Finance Act, entry 26 FF and 30 FFF of the tax free schedule, Industrial Policy Resolution 89. Therefore, in our considered opinion, the dealer is not entitled to enjoy benefit exemption tax on purchase of raw material and sale of finished products under diversification scheme. Unequivocally, we find force in submission of London SCCT headquarter appeal that levy of sales tax on the raw material valued at rupees 16 lakhs so and so, sale of finished products valued at 36 lakhs so and so, 4%, 12% respectively, and surcharge 10% on finished in the premises. The appeal order is set aside, and the case to be remanded to the SCST to make good of the deficiency by issuing appropriate notice to appellant as to why tax mentioned, that is to enhance the assessment. And so now, what is over and above? There is the expression, if your Lordship will see the language, and over and above existing production.
We'll continue after lunch. This is special.
Minus.
Yes. Jane.
Am I audible, ma'am? My learned senior, Mr. Salve, is appearing.
Salve is appearing.
Salve just joined with us.
As per your
May I
lordship,
just enter, my lord? We have already filed the counter. Lordship may peruse the counter.
Copy has not been sought to the state.
Oh,
but in the
where is
meantime,
the counter?
Copy has already been served to the council for other side also.
This is for Indian Bureau of Mines.
Yes, my lord. Yes.
Have you received it?
Yes, my lord, we have received it, my lord.
All right.
Both state
we
and
have
central
it.
government.
All right. Yes, Mr. Salve.
My lord, they have, as it were, conceded the position.
Okay.
If your lordship sees their counter, my lord. But they haven't still fixed the price. Now we are in a very interesting situation that we have a separate class of ore for which there is no price.
Mr. Salvi, the only difficulty is neither the state government nor we seem to have a copy of the counter affidavit filed by the IBM.
Oh, I apologize. We have received it, my lord.
Mr. Padhi, when did you file and serve it?
But it's necessary for the court to see it.
One, then we can give a hard copy of the same to the court also.
It was filed and received by us on
Already
6/5, my lord, as per your lordship's order.
So we can have it tomorrow, day after, whenever is convenient.
All right. All right. No, but only that we'll have to sit back. Maybe we can have it on Friday then. It'll be easier for us.
Friday.
Or the counter affidavit filed by the Indian Bureau of Mines be placed on record and also be served on counsel by the state.
The state has also filed a counter affidavit.
We have also filed the counter and served the copy.
All right. The state counter also be placed on record. List on Friday?
Maybe also. Yes, my lord.
List on Friday, sir. Friday.
Yes.
13th. Friday at 1 p.m.
1 p.m. Yes.
Grateful, man.
All right.
Grateful.
All right, Mr. Sir.
Okay.
elements. Yes, I have given a compilation of documents, Milords. I have already placed, Milords, the order passed by the Honorable Tribunal, impugned for Lordship in this revision application. Lordship may kindly see. Do. Because on this diversification, there was doubt all through and clarification issued by one of the general managers, Sambalpur, acting under the Industry Department. The Lordship may kindly see on page 7. Page 7. Thereafter, I will place other documents. This is issued to another industry, not to myself, of course. Clarification regarding EMD program. Your letter is so. With reference to the letter on the subject cited above, I am to intimate you that originally your unit registered height number so and so for manufacturing of aluminum utensils having annual installed capacity of 116.4 metric ton with effect from 2687. Later on, you have started manufacturing of aluminum circles with effect from 2/12/93 by EMD program under IPR 89. Since you are manufacturing aluminum circle under your EMD program, the new item is the diversification of the original one. Further, the annual existing installed capacity of aluminum circle was nil before the EMD program and 240 metric ton after EMD program. This is for. So therefore, according to this clarification, in case of diversification, because this item was not produced earlier prior to taking diversification, so the installed capacity, production should be nil because there is nothing earlier. Now this is produced. So therefore, the entire quantity, you cannot say that the earlier installed capacity, even if you do not manufacture, will be subtracted or you have to pay tax on that. That is clarification. Now, my lords, your lords may kindly see page 1 of the. This is a letter which is issued by Under Secretary to Government to the Senior Deputy Accountant General. And along with this letter, your lordship will find subject clarification of IPR 89. And the annexed communication, your lordship may kindly see, starts from page 2. Issued by Director of Industry, Joint Secretary to Government, and subject clarification of IPR 89. In inviting a reference to a letter number so and so, I am to furnish herewith the views, comments on each point as raised by Accountant General, Orissa, Bhubaneswar. So there is also doubt for which clarification was communicated by Director of Industries to the Joint Secretary to Government. So let's kindly see next page. It starts from paragraph E, small e, page 3. As per provisions of IPR 89, the industrial units undertaken EMD projects are eligible for sales tax benefits only to the extent of increased capacity over and above the existing capacity, irrespective of items manufactured by the original units. Next is existing installed capacity, means the capacity recorded in the permanent registration certificate at the time of issue of the same, and there is no provision to amend the same capacity frequently unless undertaken EMD, provided that such EMD should fulfill the criteria as defined in the relevant IPR. Similarly, in no case, original capacity recorded in the PMT can be reduced for the purpose of availing the incentive. In this connection, this office has already clarified that once eligible certificate for ST concession issued, it cannot be amended with every increase in fixed capital investment by this office letter number so and so. One more only I will place. There is no provision in the IPR or operational guidelines to amend the eligibility certificate for ST concession issued earlier by the Director of Industry Center frequently at any increased capacity and investment unless it is fulfilled the expansion. Only in case of expansion or modernization, installed capacity can be varied. Otherwise, the original installed capacity cannot be allowed to vary from time to time for availing incentives. Plus, one decision which Honorable Jharkhand High Court, of course, our High Court, I could find one, that your lordship will find in the case of Tin Plate of India Limited versus State of Bihar. And relevant paragraph is paragraph 13 only. One paragraph only I will place. That is at page, my lords, 28, my lords. Running page 20, one paragraph. That's in view of clause 15 of SO number so and so, dated to 2nd March 2000, where diversification of a unit is quite distinguishable from expansion or modernization of the unit, and diversification of the unit cannot be equated with expansion or modernization of the unit. In case of diversification, the facility of exemption of sales tax will be available on such raw materials which has been used in the commercial production and which has not been earlier produced by the unit, and that the product manufactured is a new one. Therefore, in case of diversification, there cannot be any incremental production, which proceeds on the basis that the production of the relevant year should not exceed 2/3 of the production capacity. In case of expansion modernization, the principle of production exceeding 2/3 of the production capacity is only applicable. It is relevant to mention here that this principle of production exceeding 2/3 of the production capacity cannot apply in case of diversification of the unit, which postulates the production for the first time of the new products as the raw materials are used for the first time in case of diversification. And viewed thus, the principle of incremental production has no application in case of diversification of the unit. This interpretation, here also they say you are only eligible for incremental production. Not this interpretation stands fortified due to amendment of SO number so and so, dated 2nd March 2000, referred to above, which in the effect that, and this facility shall be available to the unit to the extent of actual production as a result of diversification. That can, however, no doubt that exemption made with a beneficial object for encouraging investment in new industry or plant have to be liberally construed. The provision in the SO number so and so is made permitting tax for the purpose of encouraging an industrial activity. The said provision has to be liberally construed for all intent and purposes. It is a settled principles of law that an exemption provision cannot be denied full effect by a circuitous process of interpretation, and the liberal language used in notification must be given due weight. So if the taxpayer is within the plain terms of the exemption notification, he cannot be denied the benefit of calling in it any supposed intention, and the language of the notification has to be given effect to, based upon the facts apportioned and interpretation clause so and so, dated clause so and so, SF 57/2000, the petitioner entitled to full exemption in respect of the sales tax paid on the purchase of raw materials, HR coils production of the new product TMP, which was not earlier produced to the unit of the petitioner for a manufacture of ETP. It is equally relevant to mention here that Section 42 of Bihar Finance Act has no application to refund of the sales tax in this case, but these are not, may not be relevant. And accordingly, paragraph 14, the viewed from this petition is allowed. Now, Lords, if your Lordship will see from the revision application, the exempt certificate that is granted, Lords, how that is being wrongly construed. They say that the installed capacity you have to, that is mention of you pay tax. Pay tax, if I produced any goods from the original installed capacity, then I will be liable to pay tax. If that is totally abandoned, and I have resorted to confine to only diversification, manufacturing from diversification unit, then there is no question of any manufacturing of goods from original installed capacity. And the assessing officer, as I have read before lunch, he says that this could have been the supposed goods which you have manufactured. That is the way he has, as if I have manufactured. Now, your Lordship, kindly see the exempt certificate, that is at page 20. It starts with page 20, annexure 3. My Lordship, kindly see manufacturing of steel almirah. Here it is mentioned name of the finished product, maximum capacity that can be produced by the industrial unit as per industrial capacity. This 60 MT and 10 MT is the original capacity mirrors. Steel, what I was manufacturing earlier mirrors, steel almirah, rack, table, air cooler, cabinet. Then I underwent expansion. Expansion is steel almirah, rack, table, air cooler, cabinet. Instead of 70, now it is enhanced to 230. Your Lordship is now mirrors in this case concerned with the year 98-99. And for 98-99, the expansion is not applicable. I have not done, there is no question of any sale from expansion. It is only confining to diversification. That is also clarified in the next page, your Lordship will see. Then diversification program, foundation packing, rings, gasket plate, packing, exhaust smoke channel, all these are there, 13.1365 MT. Now, my Lordship, paragraph 2, the unit has undertaken expansion diversification as defined in IPR on or after 1/12/89 on the basis of an exclusive project report duly approved by DH Rautala and has gone into commercial production in respect of such expansion diversification on 10/9/91. Next page. Here it is now clarified clearly. The position of installed capacity of the unit before and after expansion of diversification indicated below. You can see 6th year 10/9/96 to 9/9/97. This is your Lordship is not concerned because the last one is applicable, which speaks about diversification. That is 7th year 10/9/97 to 9/9/98. Because my case is 98/99. That means this all question of exemption, whatever in this revision application, is for 1/4/98 to 9/9/98. Thereafter, no question of any exemption. So it's a matter of only for 5 months, about 5-6 months. 7th year. And 7th year, my lords may kindly see diversification items. There is no question of an expansion or original. Only lords I have manufactured from out of my diversification unit. And here, what he has said, manufacturing of steel almirah, rack table 60 MT and air cooler cabinet 10 MT, tax to be paid for the above quantity. That is for the original installed cabinet. If I will manufacture, I will liable to pay tax suddenly. And next is right hand side, the expansion. Manufacture steel almirah 230. If I go for expanded unit manufacture of this, then I'll. That is also this. Your lordship is not concerned because there is no manufacture from either from expansion or from original. Only diversification. This case is now related to diversification item. My lordship kindly see. These are again mentioned here. What I am manufacturing. Quantity is 1365 MT. This is exempted. As per certification, this is allowed to be exempted. Now, what he has done, the assessing officer precisely is of the view that had the installed capacity been utilized for manufacturing the items mentioned in the certificate of formal registration, then the goods which would have emerged, that would be exigible tax, and he was liable to pay tax, and he has calculated 8 lakhs amount out of my 36 lakh odd. And he has allowed 28 balance and 8 lakhs he has subjected to levy of tax. This is one . Secondly, now before the tribunal first appeal only confirmed first assessment order. Tribunal again expanded the scope of the entire appeal, saying that you are not, based on the only argument of the standing counsel, department representative was appearing, accepting whatever he has said, that not only you are liable to pay, you are not only liable to pay the entire turnover, 36 lakhs, but you are also liable to pay equally the purchases of raw materials which you have affected in order to manufacture this, being not entitled to any exemption purchases. So you are liable to pay for both purchase and sales. So now on this, I will be addressing regarding the scope of appeal before the tribunal. But your lordship, I kindly see for a moment section 23, subsection 3. Of the Orissa Sales Tax Act.
Yes.
Any dealer, or as the case may be the state government, dissatisfied with an appellate order made under subsection 2, may within 60 days from the date of receipt of such order, prefer an appeal in the prescribed manner to the tribunal against such order, provided an appeal under this may be admitted after the,
yes.
Then B, this is important. The dealer or the state government, as the case may be, on receipt of notice that an appeal has been preferred under clause A, may, notwithstanding that the said dealer or the state government may not have appealed against such order or any part thereof, within 60 days of the service of the notice, file a memorandum of cross objection, and such memorandum shall be disposed of by the tribunal as if it were an appeal presented within time under clause A. And relevant rule is Rule 57. I did not bother on it because Rule 57 procedure how to file within 60 days time. So therefore, what falls from this provision, if the state government is agreed by the first appeal order, it can as well file appeal for tribunal. If I am agreed, I can file. I have in this case filed appeal. State became accused. They didn't prefer to file appeal.
You cannot expand the scope of the appeal.
Minors.
Okay.
And if supposing here they have not filed appeal and I have filed appeal, again an opportunity is also available under
cross appeal.
Yes, to cross. They also did not like to have that. Now, what is the result if such a exercise is not done by the state? Your lordship have dealt it. There's Shamasundar's house case, 92 STC, which I have annexed to the compilation at page 8 minutes. Only one paragraph I will be placing for my lord's conviction. That is paragraph 6 minutes. Running page 11, paragraph 6 minutes.
Yes.
At this juncture, it is relevant to refer to Rule 50 of the Orissa Sales Tax Rule to insert the rules. Sub-Rule 3 of Rule 50 provides that the appellate authority shall not enhance an assessment or penalty unless the appellant has had a reasonable opportunity of showing cause against such enhancement. The appellate authority is therefore obliged to bring into the notice of the appellant before it material on the basis of which enhancement is proposed. On being so indicated, the assessee shall be in a position to show cause against the proposed action. The narration of facts as referred to by tribunal go to show that no opportunity was granted to the assessee petitioner to show cause against the proposed action for enhancement. This is really of no consequence in the case at hand because of our conclusion that tribunal has no power to enhance the assessment in the absence of an appeal or cross objection. Therefore, the member was not justified in directing restoration of the enhancement by the assessing officer. The part of the order is nullified. So, Milords, in absence of an appeal or cross examination by the state, Milords, the tribunal, Milords, has no power to make. Tribunal has power of enhancement, but tribunal has power of enhancement only to the least before it. To the extent Milords, appeal is grounds taken before him. If you find that no, that is under assessment, he can also enhance it. But he cannot expand the scope of appeal in absence of any cross appeal or cross objection by the state. By a later point of time on the basis of only oral submission to expand the scope and decide and enhance assessment. And one more judgment, only very brief judgment, which I have annexed to your lordship. So many dissents are there in those cases that even when the tribunal intends to enhance an assessment, he has to give a show cause notice. Your lordship may kindly see page 32, STREV 136 of 2007. It starts from page 31. In the case of Milord Santosh Traders, there are so many orders your lordship have passed in different cases. The grievance of the petitioner, I am placing from the third paragraph. The grievance of the petitioner is that the said enhancement of assessment made by the tribunal without issuing any notice under Rule 53 of the OST rules. Now, in Council for Revenue has fairly produced record. From perusal record, we do not find any notice was given to assessee for enhancement of the assessment order. Therefore, we have the opinion that the order of the tribunal initiated by non-observance of basic principle natural justice and also the mandatory provision rule where such basic principle has been codified. Therefore, the order of the tribunal cannot be sustained and accordingly the same is set aside. Matter remand to tribunal for fresh consideration according to law. Cross objection which was filed and pending for tribunal should be heard along with, in that case, cross objection filed, therefore directed to be heard together. Now, only one point I will show that where the tribunal's order resulted in enhancement of assessment. And by non-observance, this leads to vitiating the claim of the petitioner and violation of natural justice. That your lordship will find at page 40. Initially, the disallowance of exemption in assessment led to 1,53,000 some odd. Now, the knowledge tribunal says, as page 40, into page 5, he has made a calculation that not only sale but purchase are to be and total 5,43,729.28. Page 40 Milords. This knowledge tribunal seeks to enhance the assessment and directs the SCCT. Now you make fresh appellate order and comply formalities and enhance this, which is not permitted because this is beyond the scope of Milord's appeal power of the tribunal.
All right. As regards the first point regarding diversification and modernization, my lord, in many cases have held that the certificate of exemption given by the industry department that will hold the good, the tax department cannot tinker with that. My lord, may turn to page 17. I'll only show two documents: the certificate of eligibility regarding sales tax concession for purchase of raw materials and for sales. My lord, this is for purchase. My lord, page 17. My lord, may turn over the page, page 18. 7th year. To the right, my lord, 70 metric ton, that is the original quantity, tax to be paid. Thereafter, 122 metric ton, tax to be exempted. Now, here in the present case, he has so whatever he has purchased, he has shown it as exempted. What we say, now, first 70 metric ton has to be taxed, rest is to be exempted. That is next, my lord. The certificate shown by my learned senior, page 20. This is sales tax concession on finished products, the certificate. My lord, may turn to page 21. 7th year, which my learned senior showed, diversification of items. To the right, my lord, may I kindly see 1365 metric ton. Then below 545 metric ton. If your lordship would see the top of the column, first is quantity, then the next is quantity on which tax to be exempted. So 1365 is the total quantity and the to be exempted is 545. So we have only tax to the extent as per this, strictly as per the certificate. First, the original quantity to be taxed, over and above, it is to be exempted. So this is strictly as per the certificate of exemption. Now, if the dealer is in any way aggrieved by the certificate of exemption, why it is then the remedy is elsewhere, my lord. So the tax department has gone exactly as per the certificate of exemption. And as regards the second point, my lord, that the tribunal has, without there being any cross objection, that is there, my lord.
Correct.
But he has been given opportunity of hearing, my lord. Though there was no cross objection by the state, my lord.
Yeah, but the scope of the proceedings before the tribunal does not permit it to go in for enhancement, right?
Tribunal has not gone for, but he has remanded the matter to the first applied authority for taking appropriate action.
No, but after saying whatever he has said.
After saying, my lord?
After saying all that.
Yes. By issuing appropriate, yes, my lord. That is there. There was no cross objection.
Correct.
Is there.
That's
so,
it.
On the first point, we have acted as per the certificate exemption. On the next, my lord, that is there. No, there was no cross objection.
Correct. Correct.
Only one, what is over and above, I have not given, because I have collected so many definitions from this Oxford, Macmillan, and other meanings. It precisely says, and synonyms, in addition to, that means synonyms is over and above means in addition to, as well as, or to do more, what is expected. It cannot be meant that over and above means the original issue excluded. And all the dictionary meanings, starting from this French dictionary and this Collins dictionary, Webster's Willards, all these say in unequivocally yes.
Now, my lord,
the expression over and above.
I may only just say one more paragraph, since my learned senior has helped on that, page 21. The certificate also further elaborates that on which part the tax is to be exempted and which part the tax is to be levied. Paragraph 21, page 21, my lord, that certificate, paragraph 4. The unit being a small-scale industrial unit and having undertaken expansion diversification on or after 1/12/89 is eligible for exemption from payment of sales tax on sale of its finished product to the extent of increased commercial production over and above the installed capacity as it existed prior to expansion and diversification for a period of 7 years from the date of commercial production as specified in para 2 above. That, my lord, I have shown the quantity to be taxed, quantity not to be taxed. So when the certificate is clear, then now there is no question of interpretation by the tax department or by the dealer.
Only interpretation is whether this original installed capacity for the purpose of over and above, the sales tax officer can anticipate that this would have been your production, and by your imaginary hypothetical quantity in mind, he can have a quantity for the purpose of tax. Only has anticipated, and that is what this is a hypothetical calculation. He says that it would have been.
All right.
Whether that can be valid.
Orders reserved.
My side. Obliged.
Supplementarily stress admission item number 1.
May I please, your lordships? May I please, your lordships?
Yes.
Given the case, my lord, it is not respectfully brings to the kind notice of the lordships that the state of Orissa has passed the notification on dated 19 October 2012, thereby bringing the Orissa Industrial Security Force Act 2012, which strikes at the root of constitutional federalism, my lord. Because of the fact that your lords may kindly turn to page number 9, para 12, my lord.
Why haven't you brought this up for hearing so long? You mentioned it only recently. Because no notice has gone so far for 7 years.
Act of the year 2012 amended in 2013. He has filed the writ in 15, my lord.
And not brought it up for hearing for 7 years.
But it basically strikes at the root of fair administration, and it is beyond the legislative competence of the state of the state of Odisha, my lord. Because of the fact that under Article 246 of the Constitution, the legislative powers are divided between the center and the states across the union list, my lord. The list 1 and list 2. The concurrent list is list 3, my lord. List 2 grant the states exclusive jurisdiction over public order and police. That is entry 1 and 2. Thus, the state has no jurisdiction to transfer the civil power to a force that is controlled by a private industrial unit, my lord. What has happened in this case, they have brought out the notification creating a separate force, and the force under the statute need no permission from any authority to apprehend any person, my lord. So it is also against the judgment of the Honorable Supreme Court in Nandini Sundar case, my lord. Your lordship might be knowing. So also the directions of the Honorable Supreme Court issued in the DK Basu case, your lordships. That is the soul and substance of the grievance of the petitioner.
No. What does it actually do on the ground, and how is that affecting you?
This is a civil society organization, my lord. I am representing that.
No. How does it actually affect?
Your lordship, may kindly turn to page number 22, my lord. The MP notification, the running page of 22. Deputation of the force, my lord. What I have done, in fact, your lordship, will be very much clear if I will lordship to let me permitted to draw the kind attention for lordships to page number 15, that is the representation made to the Honorable Governor, my lord, by Annex 1, the paragraph number 4, my lord.
No, I'm still not clear. How is it affecting you? Yes. What is happening because of this force? How is it affecting adversely anyone?
The petitioner is not directly in affecting, my lord. Then? But it is in the nature of a my lord, the PM.
No, it's a purely academic question then.
I am challenging the virus, my lord.
No, virus is one thing. Just for the sake of challenge, you can't just challenge. How is it affecting? Is it compromising on the security? What is it doing?
My grievance is that it is striking at the root of a basic structure.
What is that, sir? This is not a neat, only academic question. How does this act affect daily lives? Is it making the lives better, worse?
Milord, the fact is that, Milord, the state cannot legislate something which is beyond its control, Milord.
Sir, it has to be in some context that you have to raise this challenge, not just as an academic question, sir.
But I have also made a representation with the authority that may be decided.
No, this is not a matter for representation, but even this legal question has to be framed in a certain context. It has to affect the rights of people.
The fact is that once the authority deploys the personnel who is...
No, it has already been in operation for 7 years now. I mean, 9 years.
October 2012.
12.
Almost 10 years. Batches have been recruited and deployed at several levels.
Correct. How has it affected?
It's functioning pretty well.
How has it affected the security position? How is it detrimentally affected?
It is detrimentally affecting in the sense, my lord, because they need no permission from any magistrate, not from any court of law, to apprehend any person who is going to raise their objections, my lord.
Mr. Das, I think you've not we're not asking you to spell out the grounds of your challenge, that we understand, but in what context is what we want to know.
And my context is that, my lord, it is against the spirit of the constitution.
No.
So also, am I audible, my lordship?
No, you're audible. The question really is, we're not understanding what is the factual position, for factual context for this challenge.
But I have mentioned in para 11 and 12, my lord. That is the vital. It is, my lord, in the Orissa Industrial Security Force Act 2012 infringes the basic structure of the constitution. The public order. What they have done, my lord? Yeah. The state transfers its constitutional responsibility, that is the public order, to private entities, my lord.
Sir, the act has been in force for 9 years now. Are you able to point out instances where, because the act is the way it is affecting detrimentally anyone?
But I am bringing to the kind notice of your lordship about the legal position, my lord. Therefore, my lord, let the state.
He is only ground of challenges, my lord. The supervision of the force has been handed over to rank of officer of a rank of IG. So he's saying that cannot be done. What I understand from the pleadings, my lord.
But how?
That he has to point out.
That must result in something detrimental to the safety, security of the country. I mean, of the state.
Lord, so may kindly see section 7. What they have done in page number 21, my lord. The superintendents and the administration of the force, my lord. the superintendents of the force shall vest in the state government and subject thereto and to the provisions of this act and of the rule of any rules made thereunder. The command, supervision, and administration of
the act has been in force for 9 years now. Now you should be able to demonstrate how it has worked on the ground and how it is detrimentally affecting lives of people. We can't simply have an academic challenge 9 years later, sir. It's not possible.
It is my humble submission that
you said the challenge in the present petition is to the validity, constitutional validity of the Orissa Industrial Security Force Act 2012 as amended in 2013. So according to the petitioner, the act is unconstitutional, arbitrary, and as he repeatedly kept urging, single quotes, violative of the basic structure of the Constitution, unquote. Paragraph. The act has been in force for almost 9 years now, or over 9 years now. And the petitioner should be in a position to point out how it has adversely impacted the lives of people in Odisha. Full stop. Without there being a factual context in which to examine the neat legal questions, the entire exercise becomes a purely academic one. Full stop. Particularly since over 10 years have elapsed since the act came into force, the court would like the petitioner to come forth with a better petition highlighting what prejudice has been caused to citizens in Odisha as a result of the working of the act, if any. Full stop. Consequently, while permitting the petitioner to file a better petition, the present one is disposed of. Yes.
Supplementary list item number 2.
Please, Your Lordship. Lord, the petitioner is arguing was appointed as the junior clerk and thereafter he was promoted to the post of cashier and he was his service while he was continuing in the service, he was suspended. Your Lordship may kindly come to.
What's a prayer? Discipline.
I am challenging the removal order. Your Lordship may kindly come to page 23, annexure 4.
This is a fresh petition.
My lord.
All right. Notice. Mr. Mudali accepts notice on behalf of the opposite party. Reply within 8 weeks to the 7 September.
Supplementary list item number 3. I will please allow.
Number 3, my lords, in WPC number T052059 of 2021. There, my lords, I have challenged that allotment of 2 Soirat mine Soiras, Siren ore Soiras, in favor of the NINL. Other 2 matters have been tagged up with this, but I do not know how it is related with this.
So far as my first matter is mine, it is related with the Nilachal, the closing against the.
That is related to closure. I am not on closure. My humble submission is that these are the government lodges. This was given to while it was in the status of public enterprises. Now it is going to be private one, so it cannot be continued with that. That is what my humble submission in this writ application. It has nothing to do with about privatization, concerning privatization and all.
You Lordship may kindly see the prayer. Prayer made at page 19.
Of which petition?
Of the second petition. That is WPC 20529.
And this is mine. They are my lords directed to file counter. I have also.
Senior has challenged Annexure 7 and Annexure 8. You Lordship can see Annexure 7 at page 48.
No, there, my lords, I have a small submission. I am filing a petition, my lords, IA number 6220 of 2022 to bring the successful bidder, my lords, the party and to bring amendment in this. That has not been tagged up, my lords. This should be tagged up.
You Lordship can see page Annexure 7, page 48. That is the cabinet approval in principle regarding disinvestment of
No, I am not on decision expectation. I am simply on a only simple prayer.
No, but your prayer says Annexure 7, sir.
Sir, Annexure 7, so far as it relates to operation of mines and allotment of the mines, along with auction made, so far the NINL is concerned, these two mines have been tagged with this, enclosed with this. I am limiting my prayer in respect of the mines only. My humble contention that these two mines, the state government out of turn has given it to the NINL while it was in a public sector undertaking concern. Now it is going to be private one. So these two come back to the state government, and state government may auction it, and whoever will be the highest auctioneer can take it. That is what my humble submission in this writ application. And there, in the meanwhile, last date, counter was filed that disclosing that the private bidder has been selected. That is what I filed a petition for amendment to implement a party. That is IA number 6220 of 2022. That has not come.
Yeah, that's not on record. That application is not on record, sir.
No, my lord, I have OP number 5. The MMTC has filed the affidavit, my lord.
We also filed a rejoinder to that. But here, IA number 6220 of 2022.
It was filed on 23rd of February.
Counter. Counter I filed, and I have also filed a rejoinder. So far that MMTC is concerned.
MMTC is counter.
Here, I filed an IA to bring the successful bidder as a party to this writ application.
That IA is not there, sir.
IA is not there, that is what I filed, IA number 6220 of 2022.
If my lord senior is not pressing so far as the first prayer is concerned, your lordship may record that.
No, he's also filing an amendment, he says.
No, amendment.
Let me file that amendment. Let my petition for amendment come, my lords. Thereafter, my lords.
All right, Counsel, the petitioner states that. So do we de-link these two petitions?
Other two petitions, I think.
My prayer, so far as this petition is concerned, my lords, I am in the first sub item, my lord. But my prayer is concerned, my lords, against the same, my lords, against the privatization. That is, my lords, the NINL is going to be privatized, and it is against the spirit of the public, my lords. That is my respectful submission, my lords. And in that way, my lords, we have approached the authorities and the authorities. So, item 3.
My lord, the second case we have take the instruction, but the first case we don't have any instruction. As per my instruction is that they have already executed the agreement in the process of investment. So let's may keep you after 8 weeks. Then thereafter we will.
No, last date, my learned friend has taken time to file counter.
But the copy is what they are pressing before my lord. That was copy is not served on us.
No, the copy. IA is something for amendment, my lords. IA is for amendment.
No. First question: do we have to de-link these two petitions?
No, the de-link, my lords, that they are on the merits for the privatization is concerned. They are challenging it. I am limiting my contention so far that mines is concerned. Allotment of mines.
If the prayer, first prayer is deleted, then my lord can delete.
No, that I will see, my lords. That will see, my lords, after.
No, because your first prayers are common. It's linked, yes, sir.
All right, my lord, all these matters may be taken up. There is no problem. Right. There is no problem.
In WP Civil. But replies have to be filed in first one also.
Notice also to be sent to all the opposite parties.
All right.
In second case, I am appearing for OP number 9.
Second case?
First case, you say notice.
Lord, except MMTC, Lord, OP number 5, I have filed the counter. Otherwise, Lord, and for the central government, my learned senior is there, Lord, ASG. But I think for OMC is Mr. Mudul is appearing. But EPICL, NMDC, and NINL, these three entities notice to be sent.
See, Mr. Sandas accepts notice for opposite parties. 1.
Lord,
may I pray, my lords? This let the
1, 11, and 12.
May I pray, my lords? Let the interim application come. There also I pleaded my lords to amend the cost title to bring that successful bidder as a party.
So in 33924 you are not amending. That's his.
No. That's not mine.
Notice. So he accepts notice for opposite parties 1 and 1 and 12. 1, 11, and 12. Mr. Padi, Leonard AGI, together with
Mr. BK Padi.
Accepts notice for opposite party number 2.
Virendra Kumar Padi.
Replies be filed within 8 weeks to join up the next date. Notice to all the other opposite parties were registered speed post returnable by the next day. They are also directed to file the respective replies within 4 weeks of service of notice. August 22nd. The second matter, you say Mr. Mahapatra and counsel to the petitioner states that he has filed IA number 6602.
That is that is
yeah, 6220 of 2022 for amending the writ petition. The said application be placed on record. List on same day, right?
2nd of August, man?
No. 22nd.
Supplementary
this
item
month?
number 4.
22nd August. Right.
Mine posted to 22nd of August, my lords. Can it be taken off, my lords, so that notice can be taken, my lords, in this meanwhile?
Your application should come earlier, sir.
My application may be taken up next week, my lord. There is no problem. There inclusion of party, and I have to file my consolidated writ application.
All right. Again, you say notice and parties accept notice. All right. Same date.
Supplementary list item 4.
IN number, my lords, 6220 of 2020.
Your Lordship, on 20 identical matter of the same group on 27th of April, Lordship have issued notice that Lordship will remember that transfer of case records from one place, that is from Raurkela to Sambalpur.
The matter is appealable because he has already.
My lords, Lordship identical, same group. Just a minute, Mr. Chimaka, you have not seen also Annexer 4. You cannot do faceless assessment. Lordship will kindly see Annexer 4, page 16. It is clear by, and this is a 153 assessment. Lordship will kindly see Annexer 4, page.
Same order.
Same order.
Supplementary list for admission item number 5.
Lordship have directed by order dated 23rd March 2022 to file. Directed the petitioner association to file return copy and balance sheet and other document. But with much difficulty, I could able to find out filed an affidavit to the effect of annexing the document from 5 to 16. What happened from 17 onward, the office of the association has been logged by the RDA, the Raurkela Development Authorities. So we have no access to our office. Therefore, we could not collect the document, and I have prayed for some time to file the balance document which your lordship have directed. Now coming to my lord issues.
No. First you file the affidavit, sir. Without the affidavit, you can't make. When did you file the affidavit? And you've not given all the details according to you.
My lord, I have not given the total, what your lordship directed me from 94 to till date. I have to file the return copy, balance sheet and other documents showing the earning from the mandap and other renting of the property.
Where is that affidavit? Only today.
What I beg to submit, my lord, in this affidavit, I have made a part compliance that is from 516. And this association is not coming within the threshold limit under the Income Tax Act. Therefore, it is not a assessee. So there is no return, my lord.
Maybe, but you can file your accounts.
Well, I have filed my balance sheet, audited balance sheet from 5 to 2016 and 17 onward. They have.
No, but you are supposed to file a nil return even if your assessable income is less than the taxable limit.
Well, that nobody have advised them. Anyhow, they have not been taken PAN number and have not filed.
Right. Are you carrying on commercial activity?
No, my lord, the members, there are some over the property, there is some renting has been done. All these houses which have been rented have been before a lordship. So the two activities which the association is carrying out, one is the mandap activities, and the other is that there are small kiosk like structures which have been rented.
No, but how are you without paying income tax? How are you collecting rent from all commercial shops?
Well, these are
very surprising.
Far too below the threshold limit. In either
you're giving out rent at 100 rupees a month.
Well,
people will rush to Rourkela. Are you giving shops at 100 rupees a month?
Well, very minimal. Let's say members association.
In Rourkela in 2022, you're getting shops at 100 rupees a month in Rourkela.
Since 16.
Sir, you can't even put up a tea stall.
My lord, since 16.
What are you trying to say?
My lord, since 16, the property is not in our possession. It is in the possession of the RDA. My lord, since 2006, on 22nd March 2017, this REIT application.
Sir, if your affidavit doesn't disclose the full facts,
my lord, that
or if you make misstatements, whoever is filing affidavit is going to be in serious trouble.
My lord, that's why.
Don't ask. Please warn them. They are before a high court, and if they do not speak the truth, they will be in very, very serious trouble. Very serious trouble. If you're going to try and tell me in Rourkela today you can take a shop at 100 rupees a month, we will start an inquiry then. Don't take us for granted, sir.
No, my lord,
I may be new to Orissa, but I will not go to this extent of accepting your statement that in Rourkela you can get a shop at 100 rupees a month.
Madam, conscious of your lordship's
yes,
and I have also filed an application seeking further time to file documents to the effect what your
if you are
directed.
Mr. Ratha, if you are not satisfied with this affidavit, just withdraw it. Don't dump something on us which you are not satisfied with. If we start going into it, if your clients will be in deep trouble, it's better you file a better affidavit.
My lord, I'll do it.
And if you say you're not filing income tax returns, you better disclose your full accounts.
My lord. The only problem is that let RDA be permitted us to at least access to our office so that I can take back the documents which is there. We are not going to occupy there. The RDA be allowed just 1 hour or 2 hour time so that the office of the associations which has been under their lock and key, we may be given access to get all these documents to produce before your lordship. I don't say we will go any day fixed, time fixed, we will be there.
If your lordship permits me and I can open the lock, but only after an inventory is made,
yes,
we can take back some documents.
Yes. Mr. Ratha states that the documents needed to file the affidavit pursuant to the order dated 21st March 2022 are right now in the premises which have been sealed by the Rourkela Development Authority, (RDA). He seeks permission to access those documents and for directions to the RDO to keep the premises open for that limited purpose on a few days. Counsel for the RDA states that if the petitioner makes a request for access to the documents in writing within the next week, specifying the dates and hours on which it needs such access, suitable arrangements will be made so that in the presence of the authorized representatives of RDA, 1 or 2 of the members of the petitioner will be permitted access to their documents in the premises.
I'm withdrawing that.
No, we're not even recording it. The time for filing the affidavit is now extended by another 8 weeks. Let's start. What is this IA? So the same thing. This IA?
I have given
IA for extension of time.
So in this IA, you make this order 6195.
I have given a synopsis of documents that will cover all the cases in present before lordships. That may be kept on record. I have given a synopsis of cases, all these cases, all the 17 shop rooms and the resident association, and that synopsis may be kept on record.
Why didn't you file an affidavit, sir? You get his affidavit.
No,
Then in
affidavit is
response,
alright.
you can file all this.
It should have status
Don't
also.
give loose sheets of paper, it will all get lost. You file a proper affidavit in response to his affidavit. It will be open to the RDA to file a response to the said affidavit before the next date. 12th September. Yes.
Supplementary list item number 6.
May please advance. This matter Lordship heard on 3rd of March 21 at length. This is related to an exemption notification issued in favor of IOCL under the Orissa Sales Tax Act. And now your Lordship will be dealing with this simple issue, my lords. When VAT Act came, there was no exemption and the accrued right, my lords. So the status of the accrued right because of the notification, my lords, in view of the repealing act not having such a provision and not showing any contrary intention that shall not be given, but rather having a saving clause. That is the issue. That is the issue. Well, I have given a small note, my lords.
We'll take it at the end of the board, sir.
Madam?
We'll take it at the end of the board.
Oh, ma'am. Okay, ma'am.
Supplementary list item number 7.
My lordship, item number 7 can be adjourned for short adjournment, my lordship. Because
Not able to hear. You'll have to speak in the mic.
My lordship, item number 7, actually Mr. Ratha, senior advocate, was appearing in this case, and though he was no more, he was last year he was expired, my lordship. Today we have received the file, my lordship. So, ma'am, I need a short adjournment, my lordship.
What is the matter about?
My lordship, today morning.
Is party number 1 Miller. I am in C Miller. The award of the labor code has been challenged by the management.
Right. How old is your client, sir?
Now he is about 45, 46 years.
And what was the relief granted?
The relief granted was a reinstatement. Because he was a casual laborer, and throughout the proceeding, management took the stand that he was not engaged. But on the basis of an exhibit W1, W4, and W6, that findings at para 13 of the award at page 46 Miller.
No, there's no 17B, nothing.
No 17B application was filed.
Why? How has your client survived in the last 12 years?
He is a poor man. He is a level.
Why didn't you file 17B? If he's a poor man, he should be filing 17B.
Yes, yes.
The act is made only for that.
Yes, Miller. 17B is actually not a file. That Mr. Kotia is there. That is.
Who's Kotia?
Mr. Kuntia. That is file belongs to J.K. Kuntia. But my power is there, Miller. In para 13 of the award, everything has been discussed, my lord, about the exhibit. And thereafter, they came to the findings that their workman is to be reinstated in the service. My lord.
How can this be the ground? Good, punctual, obedient work. We should be reinstated. Sir, how is this a ground, sir? The ground for reinstatement is.
Ground for reinstatement is that, my lord, that
he's punctual and obedient. That's the ground.
Punctual and obedient, and without any giving any notice.
No, that is not even the ground, sir. That's not the ground.
They are not discussed, but in the evidence I have stated. In the evidence I have stated that without giving any notice.
No, please. This can't be the ground, sir. With great respect. Right. The petition is allowed. All right.
I will kindly see.
We pass a detailed order. All right.
And I will kindly see the evidence of the.
Yes, we'll discuss all that, sir. We'll discuss all.
He has completed 240 days, Millard.
No, but that's not even the ground. Yes.
Without any notice.
No, sorry, that's not even the ground.
That portion they have not discussed. Your lordship may remind this matter again. You will.
No, not after so many years. No point. All right.
He has not dealt with every point, Millard.
Yes.
So this matter may be remanded. So
No. All right.
Item number 8.
Item 8, may I please, your lordship. These petitions was before your lordship on several occasions, your lordship, regarding illegal detention of the petitioner by the jail authority, your lordship. The petitioners, the appellate court judgment came on 4/8/2009, where the sentence was modified to 7 years and default sentence of 1 year, your lordship, for fine 10,000 rupees. And by then he has already been served 10 years and 5 months, your lordship. Despite that, he was not released from custody. And subsequently, by intervention of this honorable court, he was released after around 7 months and 18 days, your lordship. 8 months, 16 days, your lordship. The dates that I have mentioned, all the dates, your lordship.
I'm appealing for the state in this, my lords.
Yes.
We have appeared. We have filed 2 affidavits, my lords. One on 8/3/2022 and another on 31/3/2022. My lord, may I take your lordships to the affidavit that I filed on 8/3/2022, my lord?
Yes.
And to the last page of the judgment, my lord, to be precise, page 20, my lords. My lord, for sake of appreciation, may I read out the sentence that has been imposed, my lord. On an overall scrutiny of the facts and circumstances of the case, coupled with the opinion of the medical officer, we are of the view that the offence would be one punishable with section 326 of IPC. In the result, we set aside the conviction under section 302 IPC and the sentence of imprisonment for life and fine of ₹5,000 in default to undergo RI for 1 year. And instead, we convict the appellant under section 326 IPC and sentence him to undergo RI for a period of 7 years and to pay a fine of ₹10,000 in default to undergo RI for a period of further 1 year. Your lordship may say the date of the judgment is August 4, 2009. By this time, he has already undergone 10 years. This is well within the wisdom of the honorable court when they have passed this order, my lord. My lord, my humble submission is that this judgment has 3 aspects. One, a substantive punishment of 7 years. Second, to undergo RI in default, my lord. My lord, default RI for default payment of a fine is not a substantive punishment, my lord. It is a penalty. It is a mere penalty which is imposed for violating the court's order. It cannot be set off or it cannot be adjusted within the period of detention, my lord. My lord, for that, I'll take your lordships to section 53 of the punishment of IPC, my lords.
No, but if he's already undergone 10 years,
he has
then
undergone.
The question, please.
No, my lord, the fact that he's saying that these 2 years that he has undergone may be adjusted, which cannot be done, my lord.
Meaning? What's the question of any adjustment? If assuming that he has failed to pay the fine, he would have served one more RI.
If he fails to pay the fine, my lord, he has to undergo 1 year of imprisonment. That is
included in the 10 years, madam.
My lord, that 10 years will not include this, my lord.
Why not? In fact, it is only 7 years.
My lord,
you're making a mistake. That 1 year may not be included in the 7 years, but 7 plus 1 is 8.
Because, my lord, at the time
he still served out 2 more years.
My lord, by the time your lordships passed this order and judgment and this appeal, my lord, they were also well aware that he's already 10 years in custody.
Correct.
Apart from that, my lord,
absolutely, which is why we substitute. When we substitute one sentence with another sentence, it is to make sure that the person doesn't serve even 1 more day in prison.
My lord, but fine, my lord, fine. He has to. My lord, can I clarify this, my lord? I take your lordships to section 53 of IPC, my lord, which shows what are the substantive punishment. They cannot run concurrently, my lord. A substantive punishment.
You're making it seem, suppose a fine, let's say a default sentence for fine was some 5 years.
Yes, my lord.
Then it makes sense what you're arguing. On the day this modified sentence was passed, he had already served 10 years.
10 years.
Where's the question of another 1 year after that?
Because if he fails to file I also forgot to mention that the judgment has another part also, which says the fine will be paid as a compensation to the victim's father, my lord. So there is 357 also comes into play, my lord. If I'll take your lordships to section 64.
Madam, just imagine. In fact, this is extraordinary. The argument is simply extraordinary. It's an argument of desperation. If I can use the word, it's a sheer argument of desperation. The man has served 3 years more than what he should be serving, correct? On the day we passed the modified sentence, he'd already served 3 years more.
Yes, my lord.
And by your argument, he should still go back and serve 1 more year.
No, my lord, we are talking of illegal detention. That is saying that he is illegally detained. That part I'm just submission, my lord. I'm not, if he has served this sentence, my lord, that is, I bow down to your lordship's appreciation. But the fact that he's saying he was illegally detained, that part I'm submitting, my lord.
No. Was he released the day after the judgment was passed by the High Court?
No, my lord. My lord, because that order
that's the question. What was the date of the judgment of the High Court?
That is 4th August 2009, my lord. The order was communicated.
Came out in April 2010.
Yes, my lord.
20th April 2010, by virtue of this honorable court's order.
So even your own calculation of 1 year goes.
No, my lord.
On your own showing that calculation goes, then he's not served 1 year.
He should have been.
Then we'll pull you up for not making him serve 1 year by your own argument. By your own argument, he should have served 1 year beyond our judgment.
He has not served beyond 1 year, my lord.
So according to you, should have. So if left to you, you will go and arrest him and bring him back. Correct?
No, my lord.
No. Let us logically understand. See, if you have put forth an argument, we should take it to its logical end. You can't put an argument for the sake of argument.
My lord,
you're seeking to argue that while he may have served 10 years, he has to another unless he pays 5,000, he should serve 1 more year. This is your argument.
Yes, ma'am.
But then why did you release him with less than 1 year?
My lord, that was the direction of this honorable court.
No. So if it was a direction only that we told you should release him after 8 months. Was that the direction?
No, my lord. Your lordship may see the warrant issued by the appellate. My lord, that order we have annexed, my lord, under section 388 CRPC, my lord, where it says this is to authorize and require you, my lord. This is the order of the fast track court to the superintendent of jail. This is to authorize and require you, the said superintendent of the district jail, Koraput, to receive the said Suresh Chandra Das into your custody, already in custody, in the said jail, together with this warrant, and carry out the aforesaid sentence into execution according to law. And this is further to authorize an inquiry in return. My lord, so the law was that a fine has been imposed on him for default. And so the superintendent, in his well wisdom, my lord, he had to detain him.
What is wisdom? Suddenly wisdom ended in 8 months. Initial wisdom is that you should serve 1 year.
For default, yes.
Then wisdom vanished. At the end of 8 months, suddenly superintendent got different wisdom.
There was
no. Let us see. If you put forth an explanation,
he has been released on bail.
If you put forth an explanation, you have to test it.
Yes.
Either it is. If you say he has to serve 1 more year, then according to you, both of us should now say arrest him, make him serve 4 more months.
No, my lord. If he pays the fine, my lord, then he.
No. We presume he can't pay the fine. So he is a poor man. He can't pay the fine. So according to you, you should be filing an affidavit saying, please order him to be arrested and put back in prison for 4 months.
Well, section 64 IPC is very clear, my lords.
Why did you release him after 8 months then? If it is so clear, why did you release him after 8 months?
He has been released on bail on securities, my lord, on section 422, my lords.
So he's still not been released according to you?
My lord.
You're seriously making that statement? He's still not released?
He has been released, my lord. He has been released on.
No. What is there supposed to bail?
D by 2, my lord. He has given on section 442 of CRPC. He has been released, my lord.
Not in pursuance of our judgment. We have set him free. So according to you, have your super authority. You will decide when he should be free.
The trial, yes. My lord, your lordship may say about Annex D by 1, my lord. He has been discharged. Warrant to discharge a person in imprisonment in failure.
So how come you released him less than 1 year then? Let us test your argument. He should have served 1 more year, correct?
My lord, that was your lordship's observation. So
which observation?
The lower court has discharged him, my lord.
I don't understand this.
My lord,
so left to you, he should serve 4 more months. This is your argument.
Yes, my lord.
I see.
In default of fine, he should have gone. He should have undergone one more year.
Even if he serves out all 10 years, again 1 more year he has to spend.
Lordship, my peruse order dated 24 2010, your lordship. Order number 6. There, this court has specifically observed.
The petitioner already served the default sentence. Is what they said.
Already served the default sentence.
24.
And by virtue of this order only, he was released, your lordship. When this court intervened in this application, your lordship.
No, she's saying we made a mistake. According to her, the superintendent is the wisest person in state of Orissa. No. 2 high court judges are not wise. Superintendent is the wisest.
No, my lord. The
superintendent, if he left to superintendent, he wouldn't have, this kind of order is no good. Superintendent, very faithful to IPC, will say,
well, as long as the warrant has come from the court, we have released him, my lord.
That's it. Otherwise, left to you, you would not.
My lord, we were bound by the judgment, my lord. We were bound by the judgment. So
suddenly, only on 20th April, you were bound. The earlier judgment, you are not bound. Just listen to your own argument. Listen to your argument. This was a reminder. This 20th April was a reminder of the judgment that we delivered in August 2009. This was to tell you how you should understand the judgment of August 2009. What you are saying is, this order is completely wrong. This 20th April.
No, my lord.
Yes.
No, my lord.
You are saying you made a complete mistake. He should have actually served 4 more months in jail. And what to do? We had to somehow obey your order and therefore we released him. This is your argument. Extraordinary. Really extraordinary. That just shows how little you value liberty. There is a whole list of case law on late release of prisoners. Do you have that? There are at least 6 judgments. Compensation has been paid for excessive detention of a person beyond what he should be retained in jail. Do you know?
So,
have you done the research, sir?
Yes, your lordship. But here, your lordship, they are dealing with the compensation part, your lordship. That's why I have not...
Sir, there have been instances, this is not the first time. That way, Orissa can claim Article 14, saying that we are not unique. There are many states in the country where prisoners have been detained far beyond what they should have been held for. Prisoners have been held for 6 years, 7 years, 8 years. After acquittal, they've served 10 years. There have been those instances. In Calcutta, there was an instance where a man stayed in jail for 14 years after acquittal. And compensation was paid. So this is a Calcutta High Court Division Bench judgment. You'll get it. All right. Please make your research. I think Calcutta is not the only instance. There are other instances too.
Lordship, grant me one more time. I'll come back with a little more clarity on my own submission.
Make an effort. No harm in trying. No harm.
No, conscious of that, my lord, that illegal detention is definitely not what the state government will also...
No. Superintendents of jail, if they say we don't know how to calculate, how to determine what should be the total sentence, then that's a sad day.
Yes. I bow down to that. I was only harping on the substance, whether he has to pay the fine.
The Supreme Court is taking a serious view when people are not released on bail. There has been so many instances in the recent past, bail is granted on day 1, till day 10, the man is still in jail.
Yes, my lord.
The court is taking a very serious view of this kind of a behavior.
Yes, ma'am. There are some procedural lapses to which we bow down, my lord. There are at times some procedural lapses and giving the security bond, and even on the part of the accused, my lord, at times they come late with a security bond.
Most of them are unaware. We are talking of a state of society where they are not aware of anything.
Your Lordship, give another date, my Lord.
Yes, we have to, because
Finally.
anyway he has to do his research. We'll have it immediately on the opening. 6 July. List on 6 July.
Item 9.
May I please, Your Lordship, my Lord? My Lord, I am in VC, my Lord.
Yes.
May I please, Your Lordship? My Lord,
Yes.
Here the petitioner, this is a public interest litigation where the students of a difficult area, my Lord, has approached Your Lordship, my Lord. Here the central government has brought a scheme for upgradation of the primary school to upper primary school to the secondary school, where the school is up to standard 8. It is to be higher secondary school, and decided to where they have decided the condition where the feeder school must have a my lord within the proximity of the catchment school of 4 kilometers, 5 kilometers, and the student strength is 50 in case of it is in a difficult area, my lord. Here, my lord, the 6 villages where the student, after completion of standard 8, they have to cross the river Rusikolia, where there is no bridge, and there are many dropouts, my lord, to Nuagad High School, my lord. So therefore, my lord, the government decided to upgrade a school which is, my lord, 7 kilometers away from the feeder catchment area schools, my lord, and in contrary to the guideline issued by the government, my lord. So therefore, my lord, they have decided that one Rangavali UP school to be upgraded to the higher secondary school, whereas the Kesara is a place where the, my lord, fulfilling all the criteria, and it is in the middle place for all the 6 villages, where the student can easily have the access to the school, my lord. So therefore, my lord, they have also filed the counter, my lord.
Yes.
Well, my lord, in para 6 of the counter affidavit, your lordship may kindly see. Counter affidavit filed by the opposite party number 2, para 6, my lord. It is further humbly submitted that at present the students of Kesara UP schools are continuing their secondary education in high school located at Nuagad, which is at a distance of less than 1 kilometer on the opposite sides of Rusikolia, and the roll strength of Kesara PUPS is in class 8 is 45, my lord. So it is fulfilling, and it is the administration must have taken into account the barriers for the students to cross the river during the rainy season and in other season to
cross the river Rusikulia where there is no bridge, my lord, facility. Therefore, the female students and other students are dropouts of, my lord, around 80%, my lord.
Just come to para 8.
Yes, my lord. My lord. My lord, this is, my lord. Yes, my lord. It is pertinent to mention here that there is already recognized, my lord, this is 5 kilometers away, my lord. And these 6 villages are connected within the proximity of 3 kilometers, where the Kesara Upper Primary School is situated. And the proposed school of Rangavali is 6 kilometers away from all these 6 villages, my lord.
It's 3 kilometers, it says. If you read the whole para 8.
My lord, that 3 kilometers, my lord, is from Kesara, my lord. That is not correct, my lord. But the other 6 villages, my lord, is concerned, my lord. The 6 villages which are concerned, my lord, it is, I have, my lord, mentioned in para 8, my lord, of my writ application, my lord, it is relating to, my lord, Nilakantapur, Subarnapur, Nagapur, Baradhagadi, and others, my lord, including Kesara. So these students are being suffered for this. They have to cross the river, my lord, or they have to travel 7 kilometers to reach Rangavali PUPS, my lord. And the Rangavali PUPS does not satisfy the criteria provided by the government that it is only 30 students. And it has it doesn't have its own, my lord, building also. Whereas Kesara is having the building, and it is the middle place for all the 6 villages, including the Rangavali, my lord. I have also given the topography under Annexure 4, my lord. Your lordship may kindly see. The last end is the Rangavali. And these 6, my lord, at page 22, Annexure 4, my lord.
Come to para 5 of an affidavit dated, there's so many counter affidavits here.
My lord, because the first one was rejected by your lordship.
The 2nd February 2019.
My lord.
There's an agreement, second affidavit of 2nd February 2019, sir.
2nd February 2019.
Come to para 5 of that affidavit.
My lord, just.
They say a bridge is being constructed on the river Rishikulia.
No, my lord, that is not completed yet, my lord. My lord. My lord, may kindly peruse the rejoinder I have filed on, my lord, para 4 of my rejoinder, my lord, affidavit, dated 15/5/2019, my lord.
This bridge over who's for the state?
My lord, I'm for the state.
What with this bridge on Rishikulia is going on and on, sir. The date of completion was 4th October 2020.
Yes, my lord. But that latest instruction I don't have. Whether
you better find out. You better find out.
I will get it and file a short appeal.
But why don't you build a school for this children in Kesara, sir? Now it's almost 5. This petition has been pending for 7 years now. You're fighting tooth and nail not to build a school. I've never seen this kind of an attitude.
No, my lord, that is not the fact, but the middle place, the place which will be convenient for all the students, the school that was upgraded. However, I will take instruction on that also. What your lordships observing, that also, that is a vital aspect. I will take instruction on that also. And more importantly, I will take instruction on whether this bridge has been completed or not.
An updated affidavit be filed by the opposite parties on whether the bridge on River Rishikulia on NH 59 has been completed. and whether any fresh decision is contemplated on upgrading the existing school at Kesara to a high school. The affidavit will be filed within 2 weeks with an advance copy to the counsel for the petitioner. Based on this, we can have in the opening weeks, 21st June.
Supplementary list item number 10.
Right, please, Your Lordship. My Lord, in
My
item
Lord, I need 2 weeks more time to file the counter.
This one.
Item 10, my Lord.
It's a 2016 matter, sir.
Well, only on last day to Lordship has directed me to file counter, my Lord.
Last opportunity to the opposite parties to file reply within 2 weeks. Rejoinder for the next date. 12th July.
Supplementary list item 11.
The opposite party number 3 has not filed the counter. And
You are for the?
I am for the petitioner.
What's the matter about, sir?
The petitioner in this writ petition prays for a declaration of his position in a higher position in the gradation list, my lord.
Okay. You want to file a rejoinder?
My lord, I have not filed.
Okay. Rejoinder we filed for the next day. 10th August.
Supplementary list item 12.
On the last occasion, we have received counter affidavit filed by opposite parties number 1 and 2. We pray for some time to file a rejoinder.
Rejoinder be filed on 17th August.
Supplementary list item 13.
Well, it is 17, my lord. 12.
Yes.
13 lords.
Item 13.
13 lords will pay for time for filing of rejoinder lordship.
Rejoinder for the next day. This on 24th August.
Supplementary list item 14.
14, my lord, your lordship, kindly see order dated 10/11/2021, my lord. Your lordship order. Last order, my lord, 10/11.
Has the road been repaired?
Today I am filing the instructions which I have received. There are 2 letters, my lord, we can say. The one letter is addressed by the ADM that indicating that the work has been approved by the government. In the lordship, the next page, that is the work order. Your lordship can see 10/1/2022.
But today we are in May, so that's 4 months ago.
Yes, work has been
A further
awarded.
affidavit be filed by the opposite parties indicating what is the status of the work of improvement of PMGSY road from SH10 bracket A to Thakurpalli via Ulsurai. The affidavit be filed within 4 weeks. This on 13th July.
Supplementary list item 15.
My lord, the tribunal sent the order, impugned order is at under Annexure 1, challenging the order passed by the London Central Administrative Tribunal. My lord. On the last occasion, you also directed the opposite parties to file the counter affidavit. The issue here is the promotion was given during the pendency of the original application itself. And
what about the reply, sir? Who's appearing for the opposite parties? Mr. Pari?
My lord, here is the case. The state government is a major role to play, and the central government give an instruction that whatever account has been filed by the state government, that should be corrected.
Who's for the state?
Indian Forest Service.
Who's for the state?
Copy has not been served on state.
it was served on 29th of January. The advance copy was given on 29/9/21, and after 29th it was served also.
Replies be filed. Last opportunity for both the Union of India and the state to file its replies within 8 weeks. We joined up for the next. In September.
Supplementary list item 16.
16, my lords. We have filed, my lords, an intervention application yesterday, my lords. Though that is not on board, my lords, but that is with the learned court master, my lords. And I pray for a passover in this matter, my lords, because we are being led by Mr. Sajan Puvaya, senior advocate.
No, but it's okay. We just issue notice in this.
My lord, we need to file a counter affidavit.
All right.
Give us
IA 6236 of 2022. This is an application by the E-Gaming Federation seeking to intervene in the writ petition. Notice, Mr.
We have served copies
on notice on behalf of the state. Reply we filed both to the main writ petition as well as the intervention application. Within 4 weeks, rejoinders before the next date.
Intervention
14 September.
Yes, intervention application we have already served on the petitioner, my lords, as well as the state.
We have received the intervention application.
Yes, intervention
All right.
application.
All right.
Supplementary list item 17.
My lords, I'm sorry, my lords. My lords, I'm sorry. I wanted only to apologize, my lords. When you're
No problem, Mr. Boya. We issued notice in the application.
Yes, my lords. I was stuck in the Supreme Court. I'm very, very sorry. My
No problem. No problem.
No, great.
Right.
Item 17.
Item 17, my lord, on top of Mr. N.K. Sahu, your lordship on 9/3/2022 directed the State Council to file counter. Till date has not been filed. On 9/3/2022, my lordship directed
Last opportunity to the state to file a reply within 8 weeks, rejoinder for the next day. List on 20th September.
Lord, in the subsequent in the connected two matters, there are interim orders. Let that continue.
Interim orders to continue. All right.
Supplementary list item 18.
My lord, date is fixed to which?
20th September.
Item 18.
There are some allegations of financial irregularities in execution of Manrega project in a particular village in Jagatsinghpur. Now, since no action was taken, those people approached this honorable court in a PI. This honorable court directed the collector to inquire into the matter and take appropriate action. Now, collector found that the entire money has been taken away, false bill have been prepared, and it is suggested to collect rupees 2,000 as fine and to initiate criminal as well as disciplinary.
No, we already issued notice in this petition, sir.
But
Lordship, may see kindly page 27, my lord.
No, but reply has not been filed.
No, reply hasn't been filed. Lordship, may grant one more time, my lord.
Last opportunity to the opposite parties to file replies within 8 weeks, rejoinder for the next week. Same 20th September.
Supplementary list item 19.
Item number 19, lordship, on 6th, I received the
Item number 19.
Item 19, lordship, on 6th, I have received the counter affidavit filed by the state.
Copy of counter has just been received.
Is she appearing the matter?
Item 19.
Yes, item 19, please.
Item 19, lordship, on 6th, I have received the counter affidavit filed by the state, lordship. I pray 7 days time to file the rejoinder affidavit.
All right, rejoinder to be filed for the next date.
Lordship, may grant a short date, my lord, because there is stay order operating list.
6th July, interim order to continue.
Supplementary list item 20.
Item 20, I am on VC, my lords, for the CMC. My lords, this is that cutting of the tree.
Why can't any solution has been found?
Yes, my lord. According to my lord's direction, in the last date, proceedings have again been convened. The proceedings are there before my lords. I'll take they have decided on a plan of action.
Okay.
The proceedings were held on the 5th of this month. And they had said that within 2 weeks they were supposed to cut the tree. But because of this impending cyclone, the ODRF teams have been now dispatched to various parts of the state. They're supposed to come back on the 19th. Those are the main instructions. If my lord gives me 10 more days, we'll be able to do that.
All right. You say a further meeting was held on 5th May 2022, pursuant to other passed with this court, where it has been agreed that the tree would be cut at a convenient date. The city engineer CMC will fix a suitable date in consultation with all members and inform them accordingly. It is stated that the ODRAF team, which is right now engaged in the measures for countering the possible cyclone, will be back on 19th May, and the work of the tree cutting will be taken up soon thereafter. List on.
Lord, I have one sentence submission. One sentence only. The Lordship to say that precautionary measures to be taken, sufficient precautionary measures to be taken for protection of the houses and the electric line.
Obviously, sir.
Yes, my lord. In fact, the meeting in the meeting, my lord,
that's what the whole discussion is about.
My lord, I have read it. They have consented it, but only your Lordship to direct them that precautionary measures to be taken.
Yeah, all the precautionary measures mentioned in the minutes of the meeting will be taken. Right.
No, I will read.
List on 27th June.
Okay.
Fixed to
27th June.
Supplementary list item 21.
Yes, sir. Well, these are the matters that raises the question about 148A small b. Whether opportunity of hearing, and your Lordship have posted it to 29th of June.
All right. List on 29th June. Interim order to continue.
Well, may I, with your Lordship's kind permission, only add one more writ petition which I filed 2 days back. That is, and serve the copy on Mr. Standing Counsel. If your Lordship may permit me.
All right. You say taken on board notice.
11, WBC number 11-640-2022. Interim order may no
interim
steps.
order, yeah, same interim order, 29 June.
I'll file counter by that.
Right.
There is a very difficult question posed by your Lordship. I was searching. Only 2 judgments I have got here for Lordships. That is in delivered in Delhi High Court, the arm's length price. Another is amalgamation, that Maruti Suzuki's case.
Right.
And 2 judgments. And another answer which I have got, that 127. When you are transferring the file from one jurisdiction to another, you have to give an opportunity hearing. So let me research myself and Mr. Kaurav, we are researching.
All right.
I think we'll be able to get some answer.
Okay.
Much obliged, man.
All right.
Much obliged.
All right.
Supplementary list item 22.
22, my lord, it's a similar matter.
Oh, same. 29 June.
Counter has been filed. I'll file my response.
All right.
29
Joint
June.
to be filed with the next date. 29 June, interim order to continue.
Much obliged.
Supplementary list item 23.
My lord, question of law is at phase. My lord, phase 7. The reference application. My lord, you appeal. Whether in the facts and in the circumstances of the case, the ITT has rightly in law in holding that the assess's explanation with regard to addition of rupees 41,017,650 cannot be accepted as true, and whether the finding was vitiated by ignoring the relevant evidences and submissions made before it and taking into account irrelevant materials. Whether on the fact and in the circumstances of the case, ITT was right in law in confirming the addition of rupees 70,478 on account of fittings which has been sold along with the pipes, the value of which has been included in the closing stock of the finished goods. Whether on the fact and circumstances of the case, ITT was right in law in confirming the addition of rupees 6,62,393 on account of unexplained, non-existent, alleged under creditors. My lord, the facts of the case is that petitioner is a manufacturer of PVC pipes, my lords.
Yes.
The main raw material for manufacturing PVC pipe is resin. And resin is being supplied by Reliance Industries Limited. Reliance Industries in all the bills, Reliance Industries Limited is mentioning Chem Enterprise as the agent of the Reliance Industries for collection of the money. My lords, once the resin has been supplied, the Reliance Industries is debiting the money, the account to the KM Enterprise, and we are paying to the sometimes to the Reliance Industries directly and sometimes to the KM Enterprise, my lords.
Yes.
In course of assessment proceeding, the applicant has submitted in writing that KM Enterprise is the agent of Reliance Industries, my lords.
Yes.
In spite of that, neither the assessing officer nor the even First Appellate Authority, even if he has asked for demand report from other creditors, he has not asked for any demand report from KM Enterprise. So on our own, on the last date of hearing, we have submitted the ledger account of KM Enterprise along with the confirmation letter from KM Enterprise that our debit balance is this much amount, my lords. 25 lakhs amount, my lords. But in spite of that, and we have reconciled the accounts as asked by the assessing officer, but the assessing officer has rejected it on the ground that it is a lengthy process, my lords. So I am just.
Yes.
The appellant has shown Reliance credit balance of Reliance Industries at 2 crores 16 lakhs 50,327 and debit balance on account of KM Enterprise 1 crore 65 lakhs 32,778. So credit balance should be 51 lakhs 17,549. The assessing officer after that had considered the confirmation statement furnished by Reliance Industries. So when the assessing officer asked for the confirmation from the Reliance Industries, not from KM Enterprise, and the Reliance Industry confirmed that amount is 9 lakhs 38,898. So balance is 41,078,651. The assessing officer, what assessing was done, the assessing officer failed to consider the confirmation of KM Enterprise, which was produced before him before completion of assessment proceeding on 24/3/2006. That is 25 lakhs 74,770.29 at page 44 to 56, my lords, along with the journal of the KM Enterprise, my lords. Then the quantity discount accounted by Reliance Industries Limited on 2000 financial 2002 and 3, but accounted for by the assessee in financial year 2003-2004, my lords. As the Reliance Industry has already issued the discount, so Reliance Industry has debited from its account. But no, so my lords, sorry, and so we have sorry, my lords, that 14 lakhs 63,185. We have given checks to KM Enterprise, and KM Enterprise has not collected in the same financial year. KM Enterprise has collected in the next financial year, my lords. And that discount finance charges and quantity discount of 1,40,695, which Reliance Industries has given, that we have credited in the next financial year. So accordingly, we have tallied the total that for 41 lakhs, the credit balance available on account of Reliance Industries. But the assessing officer has not taken into consideration in the first instance, the assessing officer has not asked for confirmation from the KM Enterprise, even if repeatedly we are telling that KM Enterprise is the agent of Reliance Industries. And on the last date of hearing, when we filed the confirmation letter of KM Enterprise at page 57, let's see, 57. Page 57.
Yes.
KM Enterprise has confirmed this is to certify that Messrs. Joycel Pacific Tubes Limited has debited balance amount of rupees 25,74,770 as on 30/3/2003, and the same outstanding amount was received from Messrs. Joycel Pacific Tubes Limited in the accounting year 2003 and 4. And just on a previous page,
58.
that is 57. 57. The closing balance is 25,74,770, which confirms the certificate issued by the KM Enterprise. My lords, the assessing officer has added 41 lakhs to the income of the assessee appellant. My lords, in accounting standard, cash credit can be added to the income, but a debit balance cannot be added to the income of the assessee appellant. There is a bad in accounting standard, my lords.
Yes.
And against that, I filed appeal before the CIT appeals. CIT appeals, after I produce all these documents before the CIT appeals asked for remand report from the person concerned. The assessing officer, even if has asked for remand report from other assessees, assessing officer has knowingly not asked for any remand report from KM Enterprise.
Right.
But the CIT appeals, while passing the order, Lordship, at page page 21.
Yes.
I have considered very carefully the facts of the case and the materials evidence produced before me. The assessing officer accepted the contention of the appellant as well as the credit balance standing the name of Reliance Industry Limited, Mumbai, taking into account the debit balance shown through Messrs. KM Enterprise 1,65,000, 1,65,000, 32,778. The 5 checks amounting rupees 14,16,185 claimed to have been issued prior to end of the previous year, but encashed by Messrs. KM Enterprise in subsequent assessment year is not acceptable. My lords, in the calculation sheet I have given, there it is specifically mentioned when those checks have been collected by the KM Enterprise. I have given on 28/4/2003, 26/5/2003, 27/3/2003, 30th June 2003, and 15 May 2003. All are after the end of the financial year, my lords. That 14 lakhs has been collected by the KM Enterprise. Those we have given check to the KM Enterprise. Then, my lords, in as much as the party KM Enterprise would have otherwise confirmed the same while giving reply to the assessing officer. Well, in fact, the assessing officer has not called for any confirmation report from KM Enterprise, but the state appeals has passed the order on the assumption on the ground that in as much as the party KM Enterprise would have otherwise confirmed the same while giving the reply to the assessing officer. Moreover, the finance charge and quantity discount of rupees 1,40,690 was not determinable as they are claimed to be embedded in the transaction. My lord, those are in 1 lakh Annex 2 series at page 69 to 73. RCMSC 69 to 70. In the my lords, that is rate difference. So in the invoice, they have mentioned the invoice date, the material code, quantity, rate, and the amount. So obviously it is not out of that particular invoice, that this discount is not given on the body of the invoice. Later it has been given at the end of the financial year. In all the discounts given at the end of the financial year. So we have taken into the assessee has taken into consideration the next financial year, my lords. As far as the entry in ledger account of KM Enterprise for the appellant of rupees 25,74,770, the same cannot be accepted in as much as already as per the confirmation. So, my lords, no confirmation has been asked for by the state appeals. A debit balance of 1,65,32,770 was given by the assessing officer. The evidence and the explanation was held by the assessing officer as hazy and opaque. This type of interpretation of accounts in a lengthy manner in no way satisfies anybody and correctly held by the assessing officer. Under such account, I cannot but agree with the view of the assessing officer so far as the irreconcilable sundry creditors amount of rupees 41,70,650 is concerned. The addition of 41,70,650 is confirmed. Against that, I have under the assessor has filed appeal, and in the grounds of appeal, that is at page Annexure 3, page 32.
Yes.
My lords, grounds of 3. That Mr. KM Enterprise being the agent of Reliance Industries Limited and collecting payment on behalf of the Mr. Reliance Industries Limited, and the appellant having produced the ledger account of Mr. KM Enterprises as well as Mr. Reliance Industries Limited on 29/3/2006, which was not taken into consideration by the Learned Assessing Office and even refused to keep the ledger account, reconciliation statement and confirmation of Mr. KM Enterprises at the time of assessment proceeding, and the addition was made is arbitrary except bad in law. Similarly, the appellant having produced the ledger account of Mr. KM Enterprises as well as Reliance Limited reconciliation statement and confirmation of Mr. KM Enterprises before the state appeals, non-concerned same by the Learned State Appeals and confirming the addition on untenable grounds without giving any independent finding by only mentioning that the evidence and the explanation was held by assessing officer to be hazy and opaque. This type of interpretation of accounts in a lengthy manner is no way satisfied anybody as correctly held by the assessing officer. Okay, and the state appeals are added it. Now, ground number 7. That after filing the confirmation letter from state appeals, having directed the Learned Assessing Officer to issue summons and examine the parties in case of some sundry creditors, and having deliberately not issued any direction to re-examine the confirmation letter issued by Messrs. KM Enterprises and Capital Technique Limited and other sundry creditors, shows how the court of facts arise its decision by considering the materials which is irrelevant to the inquiry or act on the materials partly relevant and partly irrelevant, and is impossible to say to what extent the mind of the court was affected by the irrelevant materials used by it in the arriving at its decision. My lords, the CIT appeals, irrespective of CIT appeals, ITAT, irrespective of these grounds of appeal, while disposing of the appeal by my order at Annexure 6. At page 84, my lords.
Yes.
Well, this ITAT has committed the same mistake. Simply they have quoted the order of the state appeals. The state appeal, the assessing officer has asked for remand report from KM Enterprise, but the KM Enterprise has not given any submission, submitted any EA. With reference to 884, my lords, with reference to addition of 41,70,651 relating to the difference of credit balance shown by the assessee in the name of Mr. Reliance Limited, Mumbai, and KM Enterprises, and that reflected by the above parties in their books of account, the submission of the assessee was the same as before the AO. However, the copies of ledger account of Messrs Chem Enterprise indicating a further debit balance of rupees 25,74,700 along with certificate from the Chem Enterprise under its letterhead was furnished before the said appeals. Subledger copy with regard to the payment of checks which were encashed in the year 2004 and 5 was also furnished before the said appeals. The said appeal did not accept the claim that 5 checks amounting rupees 14,16,185 were issued by the assessee during the relevant year, but were accounted for by Messrs Chem Enterprise in subsequent assessment year.
All right. What do you say?
My lord, court has directed on 20th November 19 to produce the balance sheet. And moreover, page 91 ITT order is final and in favor of the revenue.
Orders reserved, sir. Orders reserved.
Final, sir.
Orders reserved. Correct.
Supplementary regarding consideration of irrelevant materials. Also, two decisions of the Supreme Court, my lord. Just I am placing on one para, my lords.
It's all right, sir. You mark the para on that, no? Mark the para.
Highlighted one.
Right. That's fine.
Just one minute.
All right.
Supplementary item 24.
May it please your lordship. The lordship, page 8, the tax appeal. Only one question. The lordship was pleased to allow that is substantial question of law. Amounting rupees 4,02,600 that is incurred towards the transportation charges being supported with the confirmation letter which I had produced to your lordship at page 10. It was given by the authority of the supplier stating that is carriage renewal. That is supported with the document. May please be allowed. It is small matter and your lordship substantial question of law arises. So it is accepted.
Yeah.
All right. This appeal is allowed. We'll pass it in tape.
Supplementary list item 25. Item 25.
In compliance of the order dated 7/4/2022, I have filed the compliance affidavit that is at flag B.
Let's see that.
Flag B, paragraph 4. Paragraph 3, man.
Held its meeting on 19/4.
No, affidavit dated 4/5/2020.
So totaling, there's an error. It comes to 45.5.
Yes.
On the face of the prohibition contained in the rules. What is the prohibition contained in the rules? What is the prohibition, sir?
I have not verified.
It is not be found at some point. Can you tell us what the prohibition in the rules is?
I have to verify. I have not verified that point.
Are you aware?
No, my lord, I don't have. But one more thing, if your lord, with your lordship's permission, I have already filed the judgment of the Honorable Supreme Court, wherein that is High Court of Tripura versus Tirtha Sarathi Mukherjee and others. I have filed that. By deciding the issue in paragraph 19, the question, however, arises whether Even if there is no legal right to demand revaluation as a right, could there arise circumstances which leaves the court in any doubt at all? A grave injustice may be occasioned to a writ applicant in certain circumstances. The case may arise where, even though there is no provision for revaluation, it turns out that despite giving the correct answer, no marks are awarded. No doubt, this must be confined to a case where there is no dispute about the correctness of the answer. Further, if there is any doubt, the doubt should be resolved in favor of the examining body rather than in favor of the candidate. The wide power under Article 226 may continue to available even though there is no provision for revaluation in a situation where a candidate, despite having given correct answer and about which there cannot be any slightest manner of doubt, he is treated as having given the wrong answer and consequently the candidate is found to disentitled to any marks. So my submission before your lordship is that even if there is no provision, your lordship is having the wide power to intervene in the matter when, if your lordship is satisfied about my answer.
Then we can send it for revaluation to somebody. The committee cannot do it itself. Because clearly the answers are correct. There's already a totaling mistake. Now the only question is revaluation.
Revaluation, so far as revaluation is concerned, the committee has said that in view of the prohibition contained in the rules.
Which means, I think, we are understanding that to mean that the committee itself cannot revalue.
Yes.
Unless you want to explain what the prohibition is.
Lords, kindly pass it over. I will verify the rule.
All right. All right.
I will verify the rule.
All right. Pass over.
One more pass over.
Pass over.
Supplement, passed over. Supplementary list item number 6. Passed over, madam.
Millards, 3/3/2021. I've given a note. And by the time I placed the note, Lordship said, Millard Chief said, I have already gone through it during last time. That is bad. Still, I'll place it for my.
Where is it? No.
25/4/2002. Government of Orissa have had the Finance Department notification SR number so dated 25/4/2002. Issued under Section 6, the Orissa Sales Tax Act under 47, brought amendments to Finance Department notification dated 76 for granting sales tax exemption to the oil refining unit of IOCL at Paradip. Indian Oil Corporation executed MOU with the government of Orissa for putting up an oil refinery project at Paradip in the state of Orissa, involving investment of more than 5,000 crores to generate large-scale employment. In the MOU, government of Orissa assured, committed to provide land, water tax, sales tax exemption for the project, and the package of incentives includes these are the package of incentives. Then I'll take your lordship to next date, the next notification.
This is about the interregnum between OVAT and OST. Ending of OST and beginning of OVAT.
Exactly, my lords. So sales tax was repealed. OVAT Act was introduced. That is the repealing act. The act repealed was Orissa Sales Tax Act. These notifications granting exemption to IOCL millers were issued under the Sales Tax Act. But OVAT Act had a very good provision of saving the right that had accrued. And besides this, normally your lordship goes to the intention. the intention of the authorities while amending a statute or repealing a statute or introducing another statute, if also go to the intentions, meetings held by the highest authority of the government, time to time, said, we will bring similar exemption under whatever statute, in whatever nomenclature that may come. Then they continued the work. IOCL went on investing the money. Then, my lords, when they didn't, this was delayed, maybe it's a bureaucratic delay, subsequently they brought exemption, made amendments to the VAT Act and brought that exemption. During that intermagnum period, whichever contractor, whosoever did any work, IOCL was compelled to take TDS from them, and department didn't listen to IOCL. Number of meetings took place, then they brought the exemption under the Act. The issue is this. So, the issue may not to be decided is the right that has accrued under the Sales Tax Act. If the repealing statute doesn't have any contrary intention, and rather provides a saving clause to save the accrued rights, what will be the situation? That is the thing to be decided. I'll just place these judgments so that the facts are clear to us. Because I'll place a judgment before my lord in absolutely similar situation. Supreme Court has held the here question of promissory estoppel will come, legitimate expectation also will come. And the acts which was interpreted in that judgment is Tamil Nadu Electricity Consumption Act. How previous two acts contain the exemption. The 2003 Act didn't have an exemption provision. And court said the saving clause read with Section 6 of the General Process Act saves the accrued right. And here is a case, because IOCL has made huge investment, they also can have legitimate expectation and rely on the promissory estoppel. I'll just place these dates because it's not much matters. Then by notification SR number 298, the final statement issued under Section 6 of the Orissa Entry Tax Act exempted entry tax on machineries and equipments and other settled goods required for the construction of the refinery project. Then IOCL floated, after this matter, IOCL floated tender inviting offers for construction of civil, mechanical, and electrical installation of the refinery project. Petzoner is a Government of India company members. Petzoner succeeded in the bid. IOCL clearly held out in the tender documents that the Government of Orissa has exempted entry tax and a local sales tax on goods to be sold in the execution of the works contract of the petroleum refinery unit. Then on 1505, Orissa Value-Added Tax 2004 was introduced in the state of Orissa, which repealed the erstwhile Sales Tax Act 47. Section 1042 of the new Value-Added Tax Act provided that the repeal of the Orissa Sales Tax Act 1947 shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under the repealed Act. 27505, in spite of the aforesaid provision under Section 104(2)(c) of the Orissa Value-Added Tax Act and the exemption notification under 35HH of the Sales Tax, the Sales Tax officer started demanding tax to the petitioner. Petitioner sought clarification for IOCL by letter 27505, and IOCL clarified that the exemption granted under Orissa Sales Tax Act shall continue under the value-added tax. And simultaneously, IOCL was pursuing with them and having regular meetings. In the high-level review meeting on the implementation of IOCL project under the chairmanship of Minister of Finance, the following decision was taken. For smooth implementation of the project, the exemption of tax on the works contract as under Orissa Sales Tax Act needs to continue. Accordingly, suitable notification under VAT Act 2004 may be issued with the approval of Cabinet. The state government will honor other commitments as incorporated in the MOU signed with Messrs. IOCL, keeping in view the requirement of the project and the statutory provisions in force. 2005 to 2008, IOCL continued to pursue the Government of Orissa for issuing necessary notification under the VAT Act for continuing the exemption granted under the erstwhile Orissa Sales Tax Act for the goods sold to IOCL in course of a works contract. 13/1/2019, exercising power under Section 17 (A) of the Orissa VAT Act, state government exempted the goods as goods or in another form sold in the course of the works contract. Now, execution of the works contract to IOCL from payment of tax payable under the provisions of the VAT Act. 3109, in another notification, SRO number so and so, under section 17 capital of the VAT Act, government exempted purchase of goods by IOCL from payment of tax for a period of 11 years to the date of commercial production. 659/2009. Before the notification dated 13/1/2009 was issued, petitioner had already completed the contract jobs during the period 2005-6 to 8 and 9, and the sum of ₹1,20,000 had been deducted at source and was reported towards VAT under compulsion to complete the project and the petitioner had already made assessment under section 39 of the VAT Act. A tax audit was conducted in which the department found all the account of the petitioner in order, and the audit officer recommended for the refund of ₹1,20,000 petitioner had deposited through TDS towards the VAT during the relevant period, on the ground that the transfer of goods took place in course of the execution of contract of IOCL is exempted from payment of tax. This is what during audit they observed. Since all the accounts transactions of the petitioner was found to be in order, and the refund of the tax recommended in the audit report, petitioner requested the sales tax officer to pass formal order directing to refund of the tax deposited. Though there is absolutely no question of suppression of purchases or sales or both, erroneous claim of deduction, evasion of tax, or any irregularity, and as per the audit report, refund was recommended without authority law of the sales tax officer, conducted audit assessment order 42 of the Act, and passed order on the basis of best judgment assessment and demanded 2,66 lakhs as tax and sum of 5,32,000 penalty. The sales tax officer demanded the tax on the ground that there is no exemption to IOCL under the VAT Act. My submissions are limited. That the view of the exemption notification is number so and so.
So the short question is that how do we give retrospective effect to that exemption notification from the date of repeal of the OST Act?
No. We are not on the exemption notification came under the VAT Act. So we are not on retrospective. My respectful submission, this exemption granted to IOCL under the Sales Tax Act continues because a right has accrued.
Because of the repeal and savings.
Pardon?
Because of the savings clause.
Because the savings right is section 6 minutes. Right. And in similar situation, in the last occasion, I was taking Lordship's absolutely similar case with the similar saving clause in respect of Tamil Nadu electricity consumption tax balance. High Court took a contrary view. Honorable Supreme Court said, even if there is no provision in the repealing statute granting the same exemption, if there is a saving clause, the right that has accrued shall continue. That cannot be taken away.
Right.
So, shall I take your lordship to that judgment?
Right.
It's there in my lord's record.
All right.
And in this judgment, the Supreme Court, my lord, says, in a situation like this, and a huge investment has been made by somebody on the basis of the commitment through exemption notifications, question of promissory estoppel also will come. Then there are all the judgments of the Supreme Court, starting from Indo-Afghan Agency and MP Sugar Mills, all judgments, they say that promissory estoppel is also applicable. Legitimate expectation is applicable, that it shall continue. Well, I'll take it, lordship, to this. The internal pages are right side at bottom. I'll start from page 3 millions. This Southern Petrochemical versus Electrical Inspector and others. Well, let's got it now, page 3.
Yes. Actually, I already made a note, para 29. Para 109, page 29. Para 109. Page 29.
Yeah. Yes, madam. Yes, madam. Here, they have gone to all the three acts, my lords. 39 Act, 2012 Act, and 62 Act, and 2003 Act. And they have said, because of the clause 20 of the 2003 Act, saving the exemption, so whatever exemption had been granted to them on the previous Act is saved, and the right is accrued.
Right.
My lords, then in same page, my lords, at the bottom, lords, you see, para 103. The High Court, therefore, in our opinion, committed a manifest error in opining that both the provisions relate to the same scenario. Furthermore, subsection 2 of section 20 of the 2003 Act uses the expression notwithstanding any such repeal, and thus the same cannot be construed to be notwithstanding anything contained in subsection 1 of section 20 thereof. Once the aforementioned conclusion is arrived at, it will not be necessary to construe the proviso appended to subsection 1 of section 20 in its own language. Proviso, as is well known, has 4 functions, as has been noticed in this code, in Sudhana Pillai versus V.R. Paitabidaman, so and so, qualifying for accepting certain provisions from the main enactment. Then let's straight go to para 105. In a case of this nature, the proviso restricts the operation of the repeal clause. It seeks to protect the matter specified thereunder despite such repeal. But section 6 of the General Clauses Act seeks to achieve the same purpose, subject of course to the repealing act, having no provision inconsistent with the repealed act. The 62 Act provided for grant of exemption from payment of electricity tax levied on consumption of electricity. When a notification was issued by the appropriate authority, the same had to be given a purpose. A notification issued thereunder could be an act which would come within the purview of the words anything duly done. So once by notification, it's been duly done, a right has accrued. So only the repealing statute, clearly if it takes a provision, Government of Orissa doesn't intend to give any exemption, notwithstanding of the repeal, notwithstanding the fact previous act had given such exemption, things will be different. But here that is not there. In addition to that, they have added 102C, that saving provision, the right that has accrued shall continue. Then let's see this paragraph. We are unable to agree with Mr. Adhyaruninda that exemption from tax is a mere concession diffeasible by government and doesn't confer an accrued right to the recipient. Right of exemption with a valid notification issued gives rise to an accrued right. It's a vested right. Such right had been granted to them permanently. Permanence would means unless altered by a statute. Then thus when a right is accrued or vested, the same can be taken away only by reason of a statute and not otherwise. Thus a notification which are duly issued would continue to govern only the same is repealed. Let's see, kindly go to page 31. Page 31. Let's see what it para 120. Furthermore, the exemption from payment of tax in favor of the appeal and hearing would also constitute a right of privilege. The expression privilege has a wider meaning than right. A right may be a vested right or an accrued right or an acquired right. Nature of such a right would depend upon and also vary from statute to statute. It has been so held by this court while construing section 6 of the General Clauses Act in Messrs. Gurchand Singh, Baldev Singh versus Jaswant Singh and others in the following terms. The objective of the provision is to ensure protection of any right or privilege acquired under the Repeal Act. The only exception to it is legislative intention to the contrary. That is, the Repealing Act may expressly provide or it may impliedly provide against continuance of right, obligation, or liability. Plus it goes to page 32. Page 32, madam. Then they sum up the case at hand.
So how much longer will you take, Mr. Pangari?
My lords?
How much longer will you take?
Well, it will take some time because lords, you have to hear also IOC. He's there online.
Right.
And because he will place the MOU, which will make it clear before my lords that not only the statute, they brought the statute amendment to give the exemption, but the intention they have held out to throw out.
No. So how much longer will you take?
Me, I'll take some time. If you lordship say it's okay from my side, I have made it clear, then I'll stop my lordship here.
Okay. So how long will Mr. Mohanty appears for?
Lordship, I am for the opposite part number 4, my lord. I see.
Yeah,
I will only place my lord 2-3 documents, my lord. That's all.
All right. So you'll be done in about 15 minutes?
Your lordship, 5 minutes. I will do.
All right. So we can continue tomorrow then.
Lordship, as a
You are replying?
Yeah, I will pray. Let my Lord Senior give the memo of citation.
Yeah, I'll give. And besides, let it be clear to them, 3 judgments are given before my lords regarding, because they raised the question on that day regarding maintainability of the retraction, because there is an assessment order. 3 judgments are given at the Honorable Supreme Court. These are matters not to be decided by sales tax officer. Maybe whatever may be his designation, assistant commissioner or commissioner, whatever. It has to be decided by your lordship only. 3 judgments are given. Then I'll place it in that.
All right. No, please give him the copies.
Yeah, I'll give.
No, do we continue tomorrow?
Any day, your lordship.
Any day, lordship.
Continue tomorrow. I think that's better.
Lordship.
The end of the board tomorrow. We'll continue.
Lordship, I don't want to mention my lord. In item 23, can I find out the 3 decisions?
Yeah, sure.
Item 25 first.
25 can it be called tomorrow, my lord? Okay.
All right, tomorrow.
I will check with the registry.
All right.